Good morning, all. This case management conference is in the matter of CFI 009-2023 and is being held by way of video conferencing before His Excellency Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Holman Fenwick Willen. Lead counsel is Mr. Sharif Shifji KC. The defendants are represented by Jones Day, and lead counsel is Mr. Carmi Conte. Thank you, Your Honour.
Mr. Conte, can I just clarify something with you?
Yes. Yes, my lord.
Right, I was just seeing who else is appearing in there. I think we don't need anybody other than the counsel. Thank you. Mr. Conte, you're appearing and representing the defendants today, correct?
Yes, I am indeed.
Are you aware of some exchanges with the registry about the identity of counsel who would be appearing today?
No. Yes, that it would be me. Yes, I thought it would be me. Yes.
Right. Well, there may be some confusion has arisen with another case. The name Mr. Lakshman doesn't mean anything to you?
Well, he hasn't been registered yet, my understanding, in the DIFC, so he's not appearing today. He's put in his application papers, but they haven't quite turned it around, so we thought it more appropriate for me to be appearing.
Right. Well, that was the very subject matter that I was going to have a word about.
Yes.
The position is this, and I say this not just for you, but for the benefit of anybody who may be listening. There has become a recent practice of people applying too late to the court for registration under Part 2, and the court then being put in the invidious position of not being able to interview the person concerned beforehand and facing the prospect of having to put off a hearing for someone who's not yet registered, or alternatively letting them appear in the hope that they prove themselves to be duly qualified in due course. In this case, what actually happened, as I understand it, was that an application was made to register Mr. Lakshman on the 10th of July, but no payment was made of his fee until last night after the court had closed. End result, no interview can happen until Monday. And although I have little reason to doubt that Mr. Lakshman is perfectly capable of appearing and utterly competent and so on and so forth, it's a practice that has to be deprecated when the court is put into such a position. You have, by appearing yourself, avoided the problem, and thank you for that. You are registered under Part 2, and you have appeared in front of me before, so there should be no further problems.
I'm grateful, my lord. I was unaware of all of those matters, so thank you for bringing them to my attention and duly noted. Thank you very much.
Yes, well, it's probably, I say, not just for the attention of Jones Day, but for the attention of the wider world, because there are instances where it happens where the counsel who then is allowed to appear before being registered is found not to be as experienced as he ought to be. I'm glad to say I have no doubts about that in the present case regardless, but thank you very much.
I'm grateful.
All right. With that preface, let's move to the business of the day. I've read the skeletons. I have read all the correspondence I was asked to read, except for the correspondence of the 15th of July, which has only just appeared as additional correspondence in the bundle. So if anybody needs me to read that desperately, I suppose I need to take time now to do it.
Well, I'm grateful, my lord. I don't think there is a need for you to read that now. I'm very grateful for my learned friend, Mr. Conte, who his team and our team have been liaising about the agenda for today. He very helpfully, I think, between us have managed to narrow the issues. I hope your lordship will be pleased to hear that. And we've also agreed a format. So let me just explain to you really what is on the agenda today. I think both sides take the view that it's pretty narrow, but we've identified various points on which we'd be grateful for assistance now to allow us to continue with our exercises. The deadline for disclosure is now the 22nd of September 2025. We are well on track to hit that, as we understand the position, so are the defendants. Your Lordship may note from the papers that you've already seen that the defendants issued an application on the 4th of July, supported by a 60-page witness statement. We don't understand any of that application to be before you now, and I don't believe my learned friend has identified that as part of his reading list for you today. That application deals with a couple of things which are relevant for today, which you should just note. One is security for costs, in that it makes an application for security for over $6 million. Now, that figure had never been foreshadowed in correspondence before the application was made, and it's common ground that is not for now. For today's hearing, it appears to be common ground that the claimants will issue a revised ATE endorsement of $4.9 million, and that will appear at the last item in your agenda for the hearing. And I'm hoping that will be a very short point, because I don't actually think there's anything of substance between us on that. The other point that their application deals with, which has some impact on today, are what are said to be the foreign law restrictions on the defendant's disclosure. Your Lordship will recall that this is a track we've been around on many occasions before. In the defendant's latest application, they seek effectively a blanket order excluding them from giving disclosure in relation to Swiss documents. That is a matter which has previously been before you. They've previously tried in various ways to avoid giving these documents, and each of those previous occasions they failed to persuade you. Now, as matters stand, their disclosure obligation, like ours, extends to all documents, but in any event, they're not looking for an order from you on that today. I should just mention one other aspect.
The issue, as I understand it, relates simply to duplicate documents, where some may be thought to be subject to Swiss secrecy restrictions and others may not.
Exactly.
As I understand it, you've agreed that those that are said to be subject to Swiss restrictions, if they're in the hands of another defendant, can be produced by that defendant, as long as they're identified as such and as being in the hands of the fourth defendant as well.
Exactly. That encapsulates it perfectly, my lord. In terms of our concession, there was one revision that we've made overnight, and I apologise to my learned friend for it coming so late, but it came out of a discussion we had with our e-discovery provider, which is that we say that where that happens, we do still need to have the underlying metadata for the document held by the fourth defendant, and that ought not to be covered by any Swiss restriction. And if I may, when we come to that, I'll explain to you why we say that. I'm hoping it won't be controversial. But if I may, can I explain it then rather than now? Because to be fair to my learned friend, I think he wanted to introduce this topic, and I feel that I was happy for him to do so, and I don't want to steal his thunder by undermining what he has to say before he's even had a chance to explain his position.
What I would like someone to tell me, though, at some point, is what is actually covered by the metadata in question.
Yes.
And how that's going to help anybody at the end of the day. Of course, if one normally comes across metadata in the context of dates and backdating and forgery and falsification and so on and so forth.
Yes.
But there's quite a lot of metadata that's referred to in the skeletons that I'm not sure I understand the terminology, let alone the significance. When someone talks about a file path, for example, that's not very meaningful to me.
Well, let me explain. This is going to come up repeatedly today. I may also have to educate your lordship on MD5 hash if this is something you've not come across. For me, it was an education over the last few days to understand MD5 hash, so I will try and explain that to you as well.
Well, I'm glad it's not just me.
No. Well, I will anyway. I will endeavour.
To be absolutely fair to my learned friend, it's not just him either. So I think we'll all be having a lesson in edification over the next few minutes.
Okay, well, that slightly alarms me because I don't want to now be the authority in this case on MD5 hash. But anyway, I will come back to that. So, my lord, on the metadata,
blind leading the blind.
Well, it may be on the metadata. I hope to be a bit more effective because the metadata I do understand. Firstly, putting aside the dispute today, more generally, we're agreed on the metadata that needs to be given. And my learned friend, that's been identified in correspondence. And my learned friend has also identified that in his draft order. Let me just, sorry, my lord, just give me one moment. So this was identified in Jones Day's letter of the 10th of April, paragraph 6.1. But essentially, it covers the file name. I'll just take you through each of the items and explain what the relevance is. So the file name is the file that the name that the file has been saved as on the system. And sometimes the file name can be illuminating as a subject line, essentially, to what the contents of the document, especially if it's a brief document. You can imagine, for example, a note of a meeting where the document itself may not actually reveal what it is, but the title, this file name is note of meeting of X date. So file name is its common ground is relevant metadata. The file path is where the file is saved on the server. Now that is essentially a shorthand to understanding which person or department held the file. So for example, in this case, we'll come back to this later on, but one of the issues is the relaunch plan email that your lordship might remember. There is going to be no doubt a lot of examination at trial as to what discussions there were about relaunch, which aspects of the fourth defendant's business was involved in those discussions. And you may recall from previous hearings in this case that the fourth defendant itself organises its affairs by department, and there are people sitting within the executive team, there are people sitting within the board team, there are individuals sitting within legal, etc. So the file path will tell you.
Mr. Shivji, you've gone mute so far as I'm concerned.
I'm so sorry. Have I just Mr. Conte? Can Mr. Conte hear me? He can.
I can't hear anything. Is it me or you?
Can you hear me, my lord? Can you hear me?
I'm going to dash out and come back.
Very good.
Can you hear me now? Can I?
Yes, we can.
No,
I can hear you.
There's some issue at my end. I've had this
once or twice
when I've come into Teams. It takes 2 goes to get it back again.
Can you hear me, my lord?
I'll dive out and come back. Can you say something again, Mr. Shivji, and see if I can hear you?
Yes, my lord. Can you hear me now?
No.
Oh, I'm so sorry.
No good.
Can you hear me?
No good at all. Let me just see what I can do.
Hello, sir. Jeremy, I'm Ken from Lloyd, sir. If I can help you, sir, with the Teams.
My laptop is telling me it can't find a speaker for the moment. I'll try my.
My lord, is that any better?
Yes, I've got you now.
Oh, brilliant. Okay. Well,
it just seems to come and go for no apparent reason.
Can I just please check you can also hear me, my lord?
Yes, I can. Thank you. As soon as I can hear one, I can usually hear everybody. Just the whole sound system seems to duck out, and it suddenly tells me speaker not available, by which it means my speakers, I think.
Great, thank you.
Anyway, we're there. So I missed out on you just explained file path dealt with which person or department held the
Yes.
file and so on and so forth.
Yes, so that's just it's a shorthand for giving custodian information, so which person might have had the file or which department. And again, we're agreed on that as a useful piece of metadata. The next topic is the file ID, which is the which can be MD5 hash. Now, MD5. So I should say this should be a health warning, I think, on this part of my submissions. There is no evidence before your lordship on exactly how MD5 hash works. And so insofar as we get into the finer points of MD5 hash, I don't think that could be for now, because your lordship would need to have expert evidence on it or some assistance from some recognized source, of which I am not one. But I will tell you, oh, right. Have we lost you, my lord?
It's telling me couldn't find a speaker, connect one or make sure the driver for an existing device is properly installed. I'll tell you what, I'm going to try my phone and see if it does any better there.
Very good.
I'm going to leave on my computer.
Very good. There we go, my lord. Is that any better?
Yeah, I've got you on my phone, which is sound seems perfect. So
very good.
Although you're in small picture, that will do. I've got access on my computer to the documents.
Excellent. Very good, my lord. Well, that works well.
I think we'll manage.
Very good, my lord. So I was giving you a health warning about, I'm afraid to say, my expertise in MD5 hash. And I was also saying that insofar, I'm hoping, I don't think today should turn on some very microscopic analysis of how these technologies work. But in the world, if we got into a world where it did matter, then that may be an issue you would need to defer so that you could have some a more reliable expert before you than me. But MD5 hash is a technology that allows you to put a code on a particular document, and it is essentially a protocol for verifying document integrity. So and what it does is it gives you a value for a specific document that is essentially a combination of its internal data. And what that allows you to tell, according to the technology, is if one file is identical to another. So if I had, let's say I created a document on the 1st of January 2025, I had a note in it, I made no changes, and I copied it and I pasted it elsewhere on my system. So there were then two copies. You could apply MD5 hash to it. You would get an algorithm code for that document. You could compare the codes for both the documents, and they ought to be identical because the contents of the document are identical. Now, what MD5 hash doesn't capture is the metadata around the document. So let's say that I did that, and then I emailed that document to my learned friend, Mr. Sharafi, and he saved a copy of the same document on his system. Now, he would have a copy and I would have a copy. They would be identical and they would have the same MD5 hash attached to them. But the MD5 hash would not tell me or tell any other person that both he and I had a copy and how that copy was transferred between us. And so in a case, again, of this nature, where it is going to matter who has particular memos and notes and types of documents and how they were communicated between the relevant actors, the MD5 hash doesn't tell you any of that. But it is a useful technology for avoiding pure duplication. It's quite an old technology. It was invented in 1991. Like all these technologies, it's been superseded by more sophisticated technology that work in a sort of more complex and reliable way. It is not faultless, but our understanding is that for the purposes that it's likely to be deployed in this case, it is actually quite useful. And what my learned friends really propose is that where they say that the fourth defendant has documents that are subject to foreign law restrictions, you can use MD5 hash to find out the algorithmic code for that document, and then D5, and the claimants can check whether they have an identical copy with the same MD5 hash. And if they do, then D4 doesn't have to give the document disclosure. And that is a way of getting around what are said to be the foreign law restrictions. And as a matter of logic and pragmatism, we think that's a helpful proposal. The reason I gave you the explanation about what MD5 hash doesn't capture is because that explains the addition that we've added to our order overnight. And my learned friend has not had much of an opportunity to see that at all, because it would have only come to him this morning. But essentially, for us, we've been a bit of a voyage of discovery as well as to understanding in technical terms how MD5 hash works and what it captures and what it doesn't. And we have ourselves only come to an epiphany in the last 18 hours or so that it doesn't capture some things that actually we're going to need for this case. And so and our understanding, I mean, I'm not sure you need to really get into this today, but our understanding also is that the MD5 hash for an email may not be the same if you're looking at an email sent by the sender and the same email received by the recipient. And that may be something to do with the integral components of the email. But I'm not sure that it's valuable for your lordship to get into those sorts of minutiae at this stage without expert evidence. I think the only point we want to make, and I hope there's no controversy about this, is that there are limitations to what MD5 hash will tell you. So it won't tell you some of the forensic information that you would need in this case. And I will come back to that in explaining why, although we're happy with my learned friend's proposal, we think it's a helpful suggestion in terms of workaround. We will need some metadata in order just to get the picture that we say we're entitled to.
Well, there's a question, presumably, or there may be a question in relation to particular documents, not just as to whether the fourth defendant had them, but as to whether particular individual defendants had them.
Yes, that is absolutely right. So, and what the ordinary rule in disclosure is that a party gives copies of the document. So let's say that I'm not picking on people, but let's say that each of the first to third defendants each had their own copy of the same document. That would be highly pertinent in this case. And in an ordinary course, putting aside these foreign law restriction concerns, the fourth defendant would need to give disclosure of each of the first, second and third defendants' copies. And that's so that we could, as part of our analysis, know that they'd each seen the document. So my lord, that was the MD5 hash. I'll just tell you about the other metadata that we've agreed that should be given. One is the date and time of creation, the date and time of modification, and the person who last modified, and also the person who last modified, and also the time and date that the file was last accessed. Now, all of that information is again part of that forensic analysis. It's not limited to cases just of forgery. You might have, again, I mean, there's a supposition at the moment, but let's say there's a relaunch plan memo that might have gone through a number of different iterations. It might have gone between different people, amended, etc. And that metadata would tell you that. And these are things that are routinely given in discovery. And then the final thing is the file type and the file size. The file type is illuminating for technological reasons, because sometimes you get, well, you have to know the file type, otherwise you don't know what application you use to open the file. And actually the file type is fairly generic, so it's not difficult information to give. And then the file size, I think, is only really relevant for technological reasons, because the e-discovery providers need to manage the amount of data that they handle. So if they've got a large number of very large files, they will often try and break that up, because handling very, very substantial amounts of data in one tranche creates problems. And when we come to the process of actually handing over the documents in both directions, what often happens is it's batched up. So my learned friend has indicated that their disclosure might be something like 50,000 documents. It may well be that they over the course of the few days when they give that to us, they divide that up into 2 or 3 batches, because it's easier technologically to handle that, and the file size will help on that front. So that is what the metadata contains. I've explained to you in brief terms why it's legally relevant to the issues in this case. It is also technologically relevant to the practicalities in reviewing disclosure. So on our side, our e-disclosure platform is Relativity. That there's a number of sort of generic platforms that are used for disclosure. What Relativity does is you upload the documents with each of their associated metadata, and it then allows you to sort the documents in a way that makes it easier for you to review. And your lordship would have seen from the papers that the disclosure reviews are being conducted by date range, by keyword search, and the metadata allows you to do that. So for example, the date range search, the technology will be looking at the metadata to sort documents by date range before it even applies the keyword searches. And you can do more sophisticated searches. We'll also be doing searches by custodian. Theoretically, you could do searches by department because you've got the file path. And so when we get the defendant's disclosure, my learned friend says, as I said, around 50,000 documents, that's obviously quite a significant body of material for us to review. We will then be using that metadata to work out how we tackle that mountain, because we can't simply just do a manual review of 50,000 documents in a disorganized way. We would undoubtedly want to put them into chronological order using the metadata. We may well sort them according to author. We may well be looking at dates that things were modified, etc. So the metadata is, we say, crucial to that, to actually minimizing the cost and efficiency of reviewing what you get. And that seems to be common ground, because on both sides, we agree that metadata must be provided associated with each of the files. And your lordship may also recall that in this case, we've essentially adopted the English disclosure rules approach on electronic data. There is an electronic data practice direction under those rules, and the electronic data questionnaire, all of which have been used in this case. And that all of that essentially provides that that material is provided electronically, and it's provided with the associated metadata as a matter of course. And essentially what my learned friends, well, we'll come to it in due course, but what they're asking for essentially is a departure from the usual course, and we would say that needs to be justified. My lord, before we get into the agenda item, there's just one other point I wanted to mention, because I think it is relevant to what you'll then come to look at, which is the letters rogatory process. Now, we've been around this particular track many times in this case. My learned friend's position has always been that they would apply for letters rogatory from the Swiss courts for permission to use their Swiss documents. And just to give you a reference on that, if you go to the bundle at 4454, No, sorry, actually, we'll start with 3971, sorry.
Sorry, apologies, I don't mean to cut across you, but I just note that it is 9:30 and the batting order was for me to go first on point. So if you would please perhaps let me know how much longer you're going to be, because I am conscious we need to get through everything.
Yeah, no, of course, I understand that.
How long have we got set aside for this?
I think we're down for the day. I mean, I am hopeful that actually we can deal with the agenda pretty swiftly, but I think we're down for the day.
We are down for the day, and absolutely, I think it's imperative that we get through. My only concern is, and I hear what my learned friend says about foreign legal restrictions, but they're not on the menu for today. It will perhaps take us into what is arguably a sideshow for today, and at the risk of us not getting through the materials, there may be, I'm suggesting, some more utility in me just starting off on the first topic and us moving along, and perhaps my learned friend wants to come back to this at the end of proceedings. He can.
Well, I'm grateful for my learned friend for that, but I've got about 2-3 minutes to say on this, and it does come. It is an important part of the agenda, and I'll explain why. So I can deal with this actually very swiftly. If you go to 3971, this is my learned friend's letter of the 9th of June, and they say in the middle paragraph at the bottom, to be clear, the rogatory process is a crucial part of the proceedings, which at its heart allows our clients to engage fully and completely with the DIFC court. Now, your lordship will remember that this is a mantra that we've heard from the defence on many occasions in the past. So their position historically has been that they needed to apply for letters rogatory permission in order to give certain types of disclosure. They seem to have seriously cooled on that idea. And thus far, we've had no indication they're actually tooling up at all for a letters rogatory application. Now, the critical point that's relevant to today is they have done a very extensive disclosure review, but they seem to be saying that they have not considered as part of that review whether any of the documents are subject to foreign law restrictions. And we say that is a very surprising revelation, especially given what they've previously said about the importance of letters rogatory. And so when you come to look at some of what the next task is, what the landscape looks like in the next few months, if my learned friends are going to persist at all with these concerns they say about foreign law restrictions, they're going to actually have to identify specific documents that they say are subject to these restrictions, and they are under your order. They have to give them unless your lordship has released them from their obligation to give them. And they need to be given in September. And if they're going to make a letters rogatory application, they need to get on with that. And I'm flagging all of this because they've not yet done that review. And we just don't understand why, because that ought to have been a question. When they went through all these documents, on the list of tick boxes, they should have had a tick box saying, is this potentially subject to a foreign law restriction? And we find it very surprising they haven't done that. But that is one particular mountain that they have still got left to climb if they're going to persist with this point at all. And so when you're assessing now what you're going to order today, that noting that they've got that very big task still to come is an important consideration. Anyway, that's all I wanted to say by way of introduction on letters rogatory. I didn't want to steal my learned friend's thunder, and I apologise to him because I had agreed an agenda with him, and that's what I'm now trying to get down to. But I thought it was helpful just to sweep those points away at the beginning. In our skeleton arguments, we agree what the agenda is for today. There are 5 items. They are 1, disclosure logistics, 2, search parameters, 3, ACME documents, 4, Mr. Izel's documents, and 5, ATE. And I've agreed with my learned friend that the first one, disclosure logistics, effectively is 2. He wants to put it into 2 subcategories, which is totally fine. The first subcategory is native documents, Mr. Hussein's documents, and the scheme for copy documents. And he's going to go first on those points. I'm very happy for him to do so. I mean, essentially, he bears the burden for persuading you to depart from the usual approach, so he should go first. Can I just say that on Mr. Hussein's documents, I have a proposal that might actually lead to agreement. So I'll let him take his course.
Sorry. I think that's Mr. Elie's documents. Is the former liquidator? Sorry, is that the former liquidator you're speaking about?
It
sorry.
Is, yes.
Oh, sorry.
Yes,
my apologies. Sorry.
Yes. So I was talking about Mr. Hayder's documents. And on that, my learned friend has some submissions, but actually I have a proposal. So before he maybe spends time developing his position on that, he might just give me an opportunity to jump in and say how I can maybe shortcut matters. But I think subject to that introduction, I will hand over to my learned friend, and I'm grateful to him for his patience.
Right, thank you. Yes.
Thank you, my lord. So the first item on the agenda concerns, as my learned friend said, the format in which the parties are to disclose documents. So in this first section, I'll be dealing with 4 discrete issues, not the pseudonymisation protocol, which will be its own issue after my learned friend responds, and we tick off the first 4, as it were, because the first 4, I think, are quite short, so we can deal with them together. So on this first point, which is format for production of documents, we seek in order that both parties be permitted to disclose documents as images rather than in native format. And this is on the basis that we say any original metadata is preserved and disclosed insofar as the parties have agreed that such metadata should be disclosed. Now, my learned friend, and I'm very grateful for his description of metadata, but I think it might be of assistance if your lordship turned up page 4333 in the bundle.
Yeah.
I'm grateful. So that's a letter from Jones Day to HFW dated 10 April. And if you would look at paragraph 5 and 6, the sole point here is that the metadata is not one size fits all. It's actually quite different across categories. So if you look, for example, at paragraph 5, there is different metadata as regards emails, and then 5.2 documents, 5.3 spreadsheets, and 5.4 audio files. And that, once again, is different to metadata when you're talking about the repositories that relate just to the defendant. So if you look at clause paragraph 6.1, the H drive and W drive documents, and then over the page at the top of 4334, there are the hypersuite documents. Now, these forms of metadata are quite different because they are different depending on what the document is. So I think that's important to note, because my learned friend may have given you the impression that it's the same metadata regardless of type of document. And so when you're looking at an email, for example, metadata might cover the time, as 5.1 shows, date sent, time sent, author, sender, recipients. But that's very, very different to when you're looking at a document, which was what my learned friend was referring to, where you might get something like the file path. And that's the long string that shows you the folders and subfolders you need to click on, essentially, to get to the document at the end. So just as a preliminary point, I want to note it's actually quite different, and it's not one size fits all, and that needs to be borne in mind. So the proposal the defendant's putting forward arises out of discussions they've had with we have had with our e-disclosure provider, Ernst & Young. And Ernst & Young was not instructed at the time the parties filed their e-disclosure questionnaires. Now, based on those discussions, we understand that the better approach is to disclose all documents as images rather than in native format. And this is because documents in native format would carry with it the serious risk of inadvertent disclosure of embedded information that has been redacted or withheld on confidentiality or privilege grounds. So previously, the claimants had stated that they were concerned that our proposal would deprive them of potentially relevant metadata. They mentioned that in correspondence. However, we say that concern is unfounded. So the defendants understand from Ernst & Young that the process of uploading and downloading a document from the review platform, in both parties' cases, relativity, can alter the original metadata. Therefore, the original metadata is hived off and preserved in a separate file, and it's that file that's disclosed along with the document. However, EY have advised the defendants that the metadata file will be exactly the same whether the document is disclosed in image format or native format. In addition, yes.
I'm with you on this as matters stand. I'd like to hear eventually, come the right time, why there could be inadvertent disclosure of embedded information or anything of that kind. But on the face of it, all the metadata is going to be disclosed, and I can't see a problem. So unless there's something specifically you want to develop at this stage, I'm with you on the point.
Yes, my understanding is it's links within documents that pose the problem.
Right. Okay. Tell me what that means.
Essentially, As I understand it, and I could be wrong, I'll be corrected by my instructing solicitors, but a document may have a link inside it, and that link, if you pressed on it, would take you to another document normally, and that poses the risk of you basically following the path through to a document or to other communication that may be confidential or privileged. Or irrelevant, perhaps also.
Right.
I'm trying to, sadly, maybe displays my lack of technological understanding, but I'm trying to explain this in the simplest terms as possible. But if you'd like a more detailed explanation, I can take a moment and discuss it with my instructors.
Right. Okay. Well, I understand what you're saying.
I'm grateful, my lord. So, in addition, the parties have agreed metadata proposals to ensure that all relevant and useful metadata is provided with any document, and we've included those agreed categories in our draft order. So we say the claimant's concerned that they will lose out on useful metadata as a result of our proposal simply has no purchase. So following this, the claimant suggested the defendants could avoid any risk of inadvertent disclosure through quality control checks. That was in a letter from HFW to Jones Day dated 15 July 2025, but I won't ask you to turn it up. We say that this is not a sensible or proportionate proposal. So as we noted in paragraph 14.3 of our skeleton, the defendant's document pool for production, including family documents, is expected to be more than 50,000 documents. I think my learned friend in his helpful opening described that as a mountain of documents. So whichever adjective you'd like to use, it is a lot of documents. And so what we say is that it would be a very substantial exercise to conduct a quality control review over this entire mountainous pool of documents to ensure that there are no inadvertent disclosures of hidden, confidential or privileged information as a result of the defendants disclosing native documents. And so, as with most things in the law, general propositions can be subject to exceptions or countervailing forces. But we say it's simply no justification for requiring the defendants to perform that exercise when the same metadata will be disclosed regardless of whether the documents are provided as images or native. So what you have on one side is same metadata being provided. What you have on the other side is a disproportionate amount of time and cost spent if they were to be produced as natives. And we say the answer, when one takes that into account, is obvious. So further, we say it's notable that the claimants have not pursued either of those arguments in their skeleton. Instead, the only argument that the claimant proposes in paragraph 12.1 of their skeleton is that the default approach in England is for documents to be disclosed in native format. And that's paragraph 33 of Practice Direction 31B. So I have 2 points here on the practice direction, but just so as an aside, there's no equivalent provision in the RDC, so there's no such default rule for the purposes of this court. Though I take Mr. Shivji's point that the disclosure order does say that the English approach should be applied. But if we look carefully at what that paragraph of the practice direction says, it's quite illuminating in my submission. So it says as follows: save where otherwise agreed or ordered, electronic copies of disclosed documents should be provided in their native format in a manner which preserves metadata relating to the date of creation of each document. Pausing there. Even in England, one may depart from the general rule by agreement or court order. So the rule necessarily contemplates that there are circumstances where the default approach would not be appropriate. We say there are very good reasons to adopt a different approach in this case. And it's clear from the language of paragraph 33 that the reason for requiring parties to provide documents in native format is to ensure that they provide metadata regarding the date that the document was created. Now, the rule doesn't refer to all types of metadata. It only refers to date of creation. And here, that metadata will be preserved and will be provided as a separate file, which is in line with the paragraph 33 of Practice Direction 31B. So for all these reasons, we say it's clear that the defendant's proposal should be preferred.
Yes. Now, is it sensible that I hear Mr. Shivji on this point and we deal with these point by point?
I'm in your hands. If your lordship would find that more helpful, I'm more than happy to go point by point.
Well, it probably is simplest, isn't it? I was amused by your even in England point, but we're looking for the most practical and sensible way through this, regardless of what the rules say and so on and so forth. in terms of comparative time and expense and cost, you've made the point that if you have to do a quality control, that will add to cost. But apart from that, is there a significant difference between provision of documents in by PDF image or whatever on the one hand, and provision of native format on the other?
Sorry, I'm not sure I follow the question. So you're saying aside from time and cost, is there another difference in having?
Looking at time and cost.
Yes.
I understand the point. If you have to do a quality control, that's going to add to cost, of course.
Yes.
But otherwise, is there any significant difference between provision by one means, images, PDFs and so on, or provision of native format documents?
No, my understanding is both will provide the metadata.
Yeah, but is there any difference in cost? I mean,
a difference in cost? Yes, there is a difference in cost.
You start with documents that are in native format.
Yes.
If you've got to re-image them, presumably there's some element of expense in that.
I'm told some, but not significant, is I think the answer. But can I have a moment? Once again, these are technicalities that aren't readily available to us. Could I have one moment to confer with my instructors, if that's okay, my lord?
That would have been my understanding, that it would be some cost, but not significant.
But can I take a moment, please, my lord?
Yep. Sure.
My lord, I'm told it's difficult to predict about how much additional time and cost it may take. It's something we'd have to speak to EY about, I'm afraid, and I apologise for that. But I think a working assumption can be there would be additional cost. But we just simply don't know. Well, sorry, there would not be additional cost, or significant additional cost and time at least.
Right. Well, that, unless Mr. Shipji tells me otherwise, that's the assumption I will make. Yes. All right, Mr. Shipji.
So my lord, can I just mention that this was an issue? I mean, I don't criticise my learned friends for this, but the agenda for this hearing has shifted around hugely in the run up to this hearing, and this wasn't on the agenda until very shortly before our skeletons. And so we actually had dealt with it very briefly in our original draft of the skeleton. We actually deleted that because we thought it was off the agenda. And then when we got a letter from my learned friends on Tuesday evening, very late in the evening, and they made it clear that they were pursuing this point, now we reinstated this. So I don't say that by way of criticism of my learned friends, but I do say that as a way of explanation that these are actually quite important technological issues that involve questions of cost and time, none of which your lordship actually has evidence on. Now, just stepping back for a moment and looking at what they're proposing, they are saying that where they have an electronic document in its natural electronic form, they want to convert it into an image. That is a photo of that document rather than giving us the original document. And they want to do that for all documents. Now, this proposal has changed. I'll come back to you how their proposal has changed over time. But they want to do that for all documents. And whether that means Excel spreadsheets, whether that means Word documents that might have embedded comments or track changes switched on or switched off. I'll come back to that. Now, essentially, we object to that process, save for one exception, which is that where a party wants to redact documents, we recognise that the normal way that that is done is by converting the file to an image. And the reason for that is that if you give the native file with a redaction, the redaction doesn't really work. It doesn't delete the underlying data. Someone referred to me the other day saying that essentially the redaction is like getting a black marker pen. You can get the black marker pen on an image, but you can't really do that on an electronic file. So for redaction, we recognise this is the accepted way of doing it. But beyond that, we say that it would be inappropriate to convert their native files to photos. And we say that there are 5 reasons for that. The first is that producing documents as photos creates problems. The second is that the usual rule is that electronic documents are given in their natural electronic form. The third point is the defendants originally said that they would produce their documents in their natural electronic form, and they've shifted their position very late in the day. The fourth point is that their reasons for producing documents as photos are insubstantial and are insufficient to displace the usual presumption. And the fifth point is, until very recently, they were also insisting that we provided all of our documents in their native files. And that is exactly the process that we have embarked on, and that is what they will get from us. So I just want to develop each of those 5 points, please. The first is, my first point was that producing documents as photos creates problems. I just want to develop some of those problems. The first point is that when a document is converted into a photo, the e-discovery platforms cannot read the text in the document. And therefore, the document then needs to be converted into text using a process called optical character recognition, OCR. And your lordship referred to that a moment ago. And OCR is an imperfect exercise. And I don't know whether your lordship has experience of this. I had this in another case the other day where vast amounts of information had been OCR'd, and the OCR had misread the letter M. So every time there was an M, it had read it either as 3 I's or a capital I with 2 smaller I's, or capital I, smaller I, capital I. And this was across a whole data set. And that was just one example of OCR problems, but there were many of them. And that's because what the computer is doing is looking, it's looking optically at the character in the photo and trying to identify which is the appropriate piece of text letter to apply to that character. And of course, in cases like this, it's not just doing that in the English language, it's doing it in the full gamut of languages, including Hindi, that the individuals might have corresponded in relation to this case. So the computer is looking at its vast database of characters across all of the alphabets and saying, looking at that picture, what is the best match? And the other point I wanted to make, your lordship may have some experience of this, is that if one takes a document and photocopies it repeatedly, you get a degradation in the quality. And we say there's exactly the similar issue if you've got documents where you've got take a native form. I mean, let me give you an example of the defendant's hard copy documents. They've scanned these documents, they've OCR'd them once to get the characters out of them, they've reviewed them, they've then converted the OCR documents back to image files, and they'll come to us and they'll have to be OCR'd again. And we say that's a bit like putting things through the photocopier multiple times. The more times you do that, the more errors that you create. And the practice direction that my learned friend referred to, actually, sorry, the relativity guide in the bundle makes this point that poor quality OCR leads to problems. And I'll just give you a reference to that. If you turn up 3600 in the bundle, this is a guide on relativity, which is, as I said, e-discovery platform. They're all quite similar. And it's talking at the bottom, second penultimate bullet point about unique words in a document. And it says in the last line that if you have a high number of unique words, that might indicate a problem with the data, such as poor quality OCR. And that's absolutely right. Poor quality OCR fails to recognize the right characters, and it leads to the creation of potentially an enormous number of unique words in a document. And so if I'm conducting a search for a term, for example, using the letter M, my search is not going to pick up all of those OCRs which have incorrectly attributed the wrong letter of the alphabet to that picture of M. Now, we say it's for that reason, and I'll come back to this, that the rules normally provide that documents are provided in electronic form, and that where you have OCR copies, you give those. We know that my learned friend's when they captured all their hard copy documents, they OCR'd all of those documents, and we have that in the evidence. I'll just give you the reference, but it was 1635 of the bundle, 1738 and 1778. So they themselves recognised that OCR was the first step in conducting any review, and that's of course exactly the first thing that they did before they could apply any of their search terms or do any sorting of data, etc. Now, we had some evidence on their side from Ernst & Young in October last year, a statement of Mr. Verlat, and he said that when they were going through their repositories of electronic data, they discovered that quite a lot of it had not been OCR'd. Now, just let me explain this point, that in the old days, I say, looking at my length of my practice, in the old days when we first started using PDFs, so Acrobat files, they came in an image form, not in a text readable form. So I don't know if your lordship's ever had this, but you go to the document to try and...
Sorry to cut across you, Mr. Shivji, but do you have a reference in the evidence for that? Sorry, Mr. Verlat's evidence?
Yeah, I'm going to take his lordship to it in a moment, but I want to introduce this point. Your lordship may remember from practice a few years ago that in the old days when you went to a PDF to try and cut and paste the words in a document, you couldn't do that, and that's because it hadn't been OCR'd. And when Acrobat was originally developed, it wasn't integrated with OCR. So documents of a certain vintage will simply be images on PDFs, and you actually just need to OCR them even to electronic documents in order to put them into your disclosure review. Mr. Vallet's evidence at 1746 said that in relation to electronic documents, paragraph 58 in the middle, he was talking about electronic data that needed to be processed as part of the defendant's disclosure review. He says in the middle sentence, the size of non-searchable PDFs that have been flagged for OCR is circa 60% of the total population. So the OCR processing will take longer than expected. And the point he was making there is that in the previous sentence, he says it's normally about 20 to 25%, so about a quarter of documents, actually electronic documents, are not natively OCR'd and they need to be OCR'd. But he said this particular population has a higher level of documents that need to be OCR'd. And so we just say that's another sort of indication that this idea of essentially putting these documents multiple times through the photocopier is not going to be helpful in terms of making the review easier. So those are the points about OCR. I'll come back to what the rules say about OCR. I also just want to talk a bit more about different file types and why they just don't work if you only get an image. So the first thing is Excel documents. Now, my learned friends have changed position on this because their original position was that we'd obviously get these documents in electronic form, in their native form. They then asked for certain types of documents to be provided in image form, but they excluded Excel documents. And then in their order for this hearing, they now include all documents, which includes Excel files. And your lordship probably come across Excel in various cases. It's used for financial management, computer modeling, all kinds of things. And it's a fabulous program, Excel, because there's a lot of information that can sit within it. It has different levels of functionality. At its most basic level, where it's setting out maybe a set of accounts or calculations, it will have internal formulae in the cell that will explain to you how the numbers add up or what manipulation are made to the numbers. And I often see this in the context of accounts because you might see quite a lot of underlying data underpinning the accounts, and there needs to be various adjustments in order to get to the reported figures or management figures.
Well, I well understand that for Excel, but in this case, is that going to matter, save in the context of quantum?
Well, no, it will do, my lord, because whenever you look at an Excel document, I mean, there's a few problems. The first is that, I don't know if you've had this in a bundle ever, but if you image an Excel file and it's a big spreadsheet, it might be microscopic, or you get the alternative, which is it's over 111 pages. So that really doesn't work. I've got bitter experience of
I understand that perfectly well. What I'm asking is, how is that going to apply in this case? What sort of documents are going to be relevant Excel documents going to be relevant in this case, other than in the context of quantum?
Well, I mean, even client identification. So some of the, certainly on our side, some of the work that we've been doing is in Excel. I mean, and your lordship has seen, I mean, we'll dig them out actually, because I'm pretty sure Mr. Hussain will correct me, but I'm pretty sure that some of the client data that we've seen has come from in Excel format. Yes. Sorry, he's nodding at me. So your lordship knows that this case concerns the taking of clients, to put it neutrally, neutrally as I can. And some, as we understand, some of that client information is sat within spreadsheets. And that's because, in my experience, banks routinely use spreadsheets for collecting large data sets of information. So it's not just down to financial information. And earlier in this case, your lordship has looked at tables of information involving client names, bank account numbers, assets under management, etc. And all of that sort of information is very well served by putting into spreadsheets. So we'll find Mr. Hussain, Mr. Sharafi, sorry, will kindly find for me some references from previous bundles where we've seen Excel spreadsheets that have already been in play. But I mean, my experience, having done a lot of banking litigation, is that banks routinely use Excel for managing large amounts of data, not just purely quantum, but anything that requires a large data set, because it's a very good way. It's got a vast number of cells and columns. It's a very good way of managing large data sets. So, and in Excel, there's not just the sort of single zooming out issue. Many spreadsheets got multiple pages within them. They're called tabs. And again, you just can't work out the interfunctionality of a spreadsheet, you know, where it's pulling data from. Is it pulling it from that tab or this tab, unless you have the full spreadsheet? I do quite a lot of cases involving quantum disputes between experts and financial experts, and the experts will always give their analysis with the underlying native Excel files, because it's literally unworkable if you don't get that. So that's Excel. Mr. Sharafi will come back with some examples of where we've seen Excel used in this case. But the point also applies to Word documents and PDF documents. So Word documents, it's possible to have comment bubbles and make comments on documents. We've seen comments on documents in this case, in the documents in disclosure. You can switch those on and off. So when you image a Word document, it depends which view you're looking at as to whether you can see those comments. And the same goes for track changes, that you can see track changes in different ways. You have them totally switched off. You can have essentially a clean document, or you can have track changes shown in different ways. And again, we would need to see that where, let's say, there's a relaunch plan memo, and that's been amended. That's the sort of thing we would want to see. And the same goes just for other Word document types. So there are comments in PDFs and speaking notes and comments in PowerPoint. Again, for PowerPoint, we understand that all of that can be switched off. So you've got to make sure you're imaging the right thing. So that is why we say that technologically, giving documents as images creates problems. All of that would need to be OCR'd, and the OCR process is likely to be highly unreliable doing it like that. And the OCR process is absolutely critical before we can actually conduct any sort of sensible review of what we're going to get. I didn't describe the 50,000 documents as a mountain. I don't think it is a mountain. In the autonomy litigation, I think we had somewhere in the region of 17 million documents in disclosure. That is a mountain. But 50,000 documents is still enough documents that you need to have some way of navigating them. And what happens is, if you get the native document with its metadata, then the metadata is, to use the wording of the rules, readily available. And that means that you can easier manage the searches. And if you go to 1454 of the bundle, please.
Sorry, give me the page again.
1454. Does your lordship have that?
No, because I'm working on the PDF.
Okay.
And I always find this a problem. And I don't think it's just my incompetence, but
it's not, well, it's not, my lord. And I think in the future we will look at other technologies, because there are some good bundling technologies out there.
I mean, the problem is if you use the case file from the court, then you can put in a number at the top and it'll come up, albeit it takes a long time. If you use the PDF that's sent, you don't have any way of navigating through it, as I understand it, save by scrolling up and down.
So if your lordship opens the PDF within Acrobat, I don't know whether you've got to open within a web browser or within Acrobat. Sometimes the computer automatically tries to open it in a web browser like Internet Explorer or Google Chrome.
That's why I've got it open in Google Chrome, I think.
Yeah, I don't want to trouble your lordship now, but actually, if you close it and reopen it in Acrobat, if you have that on your computer, Acrobat is easier to navigate and allows you to insert the page number so you can go straight to the page.
Right. Well, I better check whether I've got Acrobat or not. But
yes.
Thank you for that. That's
no problem.
Could be money well spent on Acrobat.
Yeah, and actually it's free as well. Sorry, I'm now plugging Adobe, but it's free. There's a free version. There's advanced versions, but there's a free version, and actually even that's quite useful for navigation.
Okay, I'll do that. Anyway, I've got there. I'm on 1454.
So these are the guidance notes for the EDQ, the English EDQ. And under metadata, it just explains. So the usual rule in England is that a document is given in its electronic format, in its native format, with its metadata. It explains here that metadata is data about data. In the case of electronic data, metadata is typically embedded information about the document, which is not readily accessible once the native electronic document has been converted into an electronic image. And so I understand my learned friend's point that they're going to be providing the metadata. So they'll say you've got the image, and alongside this, you've got the metadata, but it's not integrated in the way that it is. It's readily available is the way that it's put here, and that's what this note envisages.
But so what?
Well, so the point I was making to your lordship was that we will use the metadata to navigate these documents, and the defendants essentially making life difficult for themselves by taking the document, converting it to an image, and then extracting the metadata to provide it alongside of it so that it can be essentially lined up with its own metadata. All of this is readily accessible in the electronic file, which they ought to be giving under the usual rule. And so can I bring you to that next? So the usual rule, which is at 2997 of your bundle.
Yeah.
No, sorry, 1 second. So I'm so sorry. 2973. Yes, it's 2973. I'm so sorry. 2973. This is the practice 31, practice direction 31B, disclosure of electronic documents. And this is essentially what we are applying in this case, because your lordship has ordered electronic disclosure and the parties have already used the EDQs under this process. Yeah. And looking at 2973 under the heading General Principles, when considering disclosure of electronic documents, the parties and their legal representatives should bear in mind the following general principles. And then number 4, electronic documents should generally be made available for inspection in a form which allows the party receiving the documents the same ability to access, search, review, and display the documents as the party giving disclosure. And that's for a number of reasons. The first reason is if you look at sub 1 under 6, electron documents should be managed efficiently in order to minimize the cost incurred. There's obviously a big cost saving if you both sides have access to the same documents in their native format. So you don't have any of these OCR, re-OCRing issues or marrying up of metadata and documents or any of that. Both sides have access to the same thing. That reduces the cost for both sides. It's also a point about fairness, because we're going to end up in a world where my learned friends have all of this material in its original native format, so they can navigate it much more quickly and efficiently than us and at a much lower cost, and we will be left dealing with the images. So that's the general approach. And if you then go forward to page 2977,
Yeah.
this then sets out slightly more detailed requirements of how you then, the mechanisms for giving that a disclosure. Then if we go forward to 32, provision of electronic copies of disclosed documents, the party should cooperate at an early stage about the format in which electronic documents are to be provided on inspection. And then in case of difficulty or disagreement, the matter should be referred to the court for directions at the earliest practical date, if possible at the first case management conference. And then 33, save where otherwise agreed or ordered, electronic copies of disclosed documents should be provided in their native format in a manner which preserves metadata relating to the date of creation of each document. And then on to 34, a party should provide any available searchable OCR versions of electronic documents with the original. The party may, however, choose not to provide OCR versions of documents which have been redacted. That was the point I made to you about redaction. That's entirely fair. If OCR versions are provided, they're provided on an as-is basis with no assurance to the other party that the OCR versions are complete or accurate. And that just captures also the point I've made to you that OCR is it risks being unreliable, and that's why essentially no warranties are made when it's given as to the quality. And we say that the reason that these are the usual rules are for all of the problematic reasons that I've identified to you. There are really good practical reasons why doing things in the way that the defendants propose causes cost and difficulty and delay in the litigation. And the scheme of all of these disclosure regimes is to absolutely minimize the cost and maximize the efficiency. So that brings on to my third point, is that my learned friends' shift in position. Now, that shift in position matters because, as I showed you in the PD, the parties are expected to cooperate on these matters at an early stage. And in the case of difficulty or disagreement, they ought to apply at the earliest practical date, if possible, at the first CMC. And we're more than a year into this disclosure process, and they're raising this now. Now, their position actually, it's always been with this court under their EDQ, is that they're working to give their documents in native format, and that's at 1466 in their EDQ. And they've never corrected that. They've never filed a new EDQ. And they also said in that EDQ on the same page that where they had searchable OCR versions of electronic documents, they would be providing them. And the EDQ also required them to say what they wanted from us, and their proposal, what they said they wanted from us was our documents in native format, and that's at 1468. In October, so this was May 2024. In October 2024, they filed the statement of Mr. Vallat from EY. EY were on board at that point, had done a full review of essentially the scoping out their discovery exercise and exactly what mechanics were required in order to get a population of documents up for review. There was no suggestion from EY that there was some technical reason that documents needed to be produced in images in due course. There's no mention of any concern about any of this and no departure from the EDQ. There was no change in that position until April 2025, when my learned friend suggested for the first time that Word, PDF and PowerPoint documents, but not Excel documents, would be provided in image form. And then, as we understand the position, it was only in my learned friend's draft order and skeleton argument that they appear to have now moved to the position that all documents should be given as images. And they say that that applies to both parties. So they seem to now be saying they don't require native documents from us. And we say the only reason they could have changed their position on us is in order essentially to cover their own position, to try and make it look like they were taking a more balanced approach. So that brings me then to the fourth point, their reasons for producing images as, documents as photos rather than native files. And we say their reasons are insubstantial and insufficient to displace the usual presumption. The only reason they seem to give is that they want to avoid inadvertent disclosure of embedded information or family documents which have been redacted or withheld. Now, I just want to focus in particular on the embedded information. The documents we're talking about are documents that the defendants have identified are relevant to this case and ought to be disclosed. If they have embedded information in those documents, that is relevant and ought to be given. That is essentially the complete version of the document. Now, my learned friends say that it creates a burden on them because they would need to go back and review that embedded information. And that's a QC process that they don't want to incur the cost of doing. But they should have done that as part of their review. We think it's actually largely unthinkable that when they reviewed these documents, they didn't actually the reviewers didn't look at the embedded information. I mean, that's a routine instruction given to reviewers. You've got to look at the whole document. You can't look at part of it. And if that work hasn't been done, it needs to be done, because your lordship is otherwise put in a position where you will be getting incomplete documents, copies of relevant documents. And the fact they're incomplete will never be known, because we will only get the image. And so we'll never see the fact that they were incomplete. It will just be lost for all time and for your lordship's benefit. And that just can't be right in relation to relevant documents. And we also consider that in all cases, there has to be a quality check of the work done. And if there is some material omission, then that ought to be spotted before the document's given. And the defendants have spent millions on their disclosure exercise. So the idea they can't get this right for 50,000 documents is unreal.
Remind me again what you said the embedded information is likely to be.
So for example, in a Word document, it might be the track changes. Track changes might be switched off. And indeed, in a Word document, you can display the document in its original form, in its amended form showing track changes, or with track changes switched off. And similarly, I don't know if your lordships ever used the comments in Word, but the comments in Word can get hidden. I've certainly had this with drafts, that someone sends you comments, you open the document, you say, I can't see anything. And then they say, oh, well, actually, you'll need to switch on the comments in your Word document. And then suddenly a whole load of comments appear that you couldn't have seen before.
Yeah, these are the balloons at the side.
Sorry, my lord?
The balloons that appear at the side.
The balloons, exactly. And they don't have to appear. Sorry, I don't want to now bore you with enormous detail, but they don't have to appear as balloons. They can appear in different ways. So that's one example, but we're just talking about Word. And as lawyers, we spend a lot of time in Word. Excel has comments as well. You can make comments on cells. That's a sort of similar thing. They appear in a bubble or not appear at all. And behind Excel, you've also got all the spreadsheet functionality, the formulae, the potentially the macros and all kinds of functionality behind that. And similarly, you can have comments in PowerPoint and notes in PowerPoint, and you can also have comments in PDF. So all of that is an issue. And can I just deal with my learned friend's point about redactions? So he says, look, there might be a world in which we've correctly redacted a document, but there are multiple copies of it, and we might inadvertently redact one of those incorrectly. And we're totally sympathetic on that sort of data management error, but that sort of issue can be managed between us. And actually, the way that should be navigated, we would say, is they could probably do that through the MD5 hash technology, that they've identified the documents that need to be redacted. They find the MD5 hashes for those documents, and then they look for all of the identical documents within their data set. And if, for example, they said, look, actually, there's 17 versions of an identical document. We've redacted one. We don't want to go and redact all 17. That's exactly the sort of thing that we could talk about and we would be sensible about. So insofar as my learned friend is raising points about inconsistent redactions, there are much easier ways to navigate that than to image the whole of discovery. So, my lord, we just say that their reasons just don't stack up, and all that they're doing is loading, essentially taking a cost that they ought to have incurred on their side for the quality of their review, and loading a separate cost onto us of the cost of not just OCRing the document, but all of the problems that will flow from OCR. I mean, it is, in electron terms, this is just running it all through the photocopier and giving us that and saying, there you go, 50,000 documents that have been bunged through the photocopier, see what you can do with that. And we just say that would be most unfair and is not what these protocols require. And so that brings us to my final point, which is it is rather telling that until very late in the day, their position was that we should be giving our documents in native format. And that's because obviously it would be far easier for them to navigate our documents. And it's only, we say, when they realized that, you know, essentially this proposal would have to have parity in April, that they then said, well, you know, we'll let you off the hook as well. So we are proposing to give this in native format. That's what we think the rules require. We're not trying to take some tactical advantage of this, but we say your lordship should resist the imaging of these files. Now, does your lordship have any questions on that? Those are my submissions.
No, thank you. Mr. Conti?
Thank you, my lord. Can I just deal with the last point first, and then I'll come back from the top. My learned friend says that we're requiring the claimants to produce documents in images. We're not. The language of paragraph 1.1 is permissive. The parties are permitted to disclose. So there's not a mandate. It's simply a permission. Can actually deal with the first point, with the fourth point, just because I can deal with that very briefly. I think my learned friend has misunderstood what embedded information means, unfortunately. Embedded information is information you can't see on a native document when reviewing it. You can see track changes, you can see comments. That's not embedded. Embedded is information that you actually can't see from doing a review. So an image will actually give you a more complete a more complete survey of the document, because you will get the actual content of the document, including comments and track changes, because that's part of the document, and you will also see at the same time the information that sits behind it. So that point was wrong. He also said at one point that there would be, it's because you can see the information, or he said because you couldn't see this information, they would need to spend more time to search for it. Well, that's actually not right. It's the inverse, actually. Because the claimants can see the information, they'll be able to navigate it more easily, which will save time and will save cost. And the last point I have on that is, if the embedded information is relevant, we'll be providing it. So there's no question about that. The only question is about the risk of passing over something that is privileged or that is confidential. But there's no question about what will actually be provided. I mean, we will provide the relevant information to the extent that it exists, the relevant embedded data. So can I just go back to where my learned friend started? It's disappointing that the claimants didn't see fit to raise a lot of these issues in correspondence. So I won't take you to it, but the first letter that my instructors sent dealing with this is the 10th of April. One would have thought, given the progress they've made with their disclosure exercise, this would have all been readily apparent to them around the 10th of April. They didn't respond in terms or in substance until early July. And these arguments that my learned friend has made right now find no place in the skeleton. And so, again, it would have been helpful for some foreshadowing, because as much as my learned friend wants to elucidate the intricacies of the technology, we will need to go back to EY to check some of the propositions that he's put forward, and evidence shouldn't be given from the bar table. It should be technical professionals to say whether information is or isn't embedded and things of that nature. So it would have been very helpful had this been covered in correspondence. So my understanding about documents in relativity is they're already imaged. You can view it as a native or you can view it as an image within relativity. The other point is that OCR has already been applied. So it's applied to an image in order to run the keyword searches, because you can't do it. Otherwise, you would need to print off the document and you would need to manually search for keywords. So the way that it's done in the modern era is you OCR the document, i.e. you image it so that the words become searchable, and then you apply your search terms. Everything is searchable. You can apply then your search terms, and that's how keywords are applied. Now, I think my learned friend is again labouring under a misapprehension that there's a second OCR process or a third OCR process. I think the correct position is OCR is applied when you do your keyword searches, and then you hand over the documents in OCR format. And so the idea that there's an analogy here with copying and copying again and copying again, I don't think it's correct. So I think it's also important to note that my learned friend talked about issues in relation to photocopying, and he tried to say there was a large issue in relation to documents that have been scanned and then uploaded to Relativity. That only relates to the W drive and only for PDFs. So it's a very small proportion of our entire document universe. My learned friend made a lot out of Excel. He made a lot of point about producing Excel. You need the tabs, you need to be able to have the native image. But the reality is, in this case, and your lordship picked up on this, a lot of those spreadsheets will be about quantum and will have sensitive information in them, confidential information and sensitive information about clients, their BP numbers and other associated information. So they will need to be redacted. That information will need to be redacted. My learned friend rightly conceded that before you can redact, you need to convert the document to an image. The other point my learned friend makes is about, well, with an Excel spreadsheet, you have the spreadsheet and then you have multiple tabs, which is essentially, if we're looking for an analogy, multiple pages of a book. Well, the simple answer to that is you just image each page. And the idea that there's some problem with that and it's more difficult to navigate is a little bit odd. In the modern era, bundles are provided in images and they contain Excel spreadsheets. And I don't think there's any argument that they're easily navigated. So the idea that that will increase cost on their side, they'll be more difficult to navigate, I think it just isn't correct. I think it's also important to note that this position isn't Jones Day articulating these difficulties. It's EY. EY are very experienced. We've gone on their advice. It's that position that we're putting forward, and they say there's a problem here. So EY were not involved at the time of the original EDQ. So my learned friend wants to make an issue out of that. But the reality is this is a very different case from when the parties filled out the EDQ. I won't take you to it, but the custodians, the size of the disclosure exercise, your lordship has sat in on various CMCs and disclosure hearings where this is a totally different case from that point. And the idea that because we didn't mention it in the EDQ and we haven't filed an amending EDQ is somehow makes a difference, I think is just, it's not commercially realistic. So another point, my learned friend took you to the usual rule in the CPRs. It's the usual rule. It talks about should generally apply. It's just a general rule. And if you read the thrust of the CPRs, they're all about minimising cost. I mean, that is what you do. With the CPRs were an initiative to try and ensure that parties spend less on this exercise. And the thrust of our objection is it will increase our costs and it will not result in any increased utility to the claimants. The only points that I've heard really are, from my learned friend on this point, well, they'll be able to navigate much more quickly and at lower cost. That's just unreal, from what I've had to say and what EY have told us. They will have all the information. They'll have the embedded information. OCR will be applied. They'll be able to navigate it. They'll not take them any additional time. It will not cost them anything additional. The only cost that's increased that's being incurred is on the defendants. And if we're willing to take the extra time to convert them to images and depart from the general rule, then there's going to be a good reason for that. We wouldn't be offering to do that unless we saw a real problem, and that's what we do. My learned friend then sought to make some issues out of OCR being unreliable. I think we need to trust OCR. It's generally what you do to a document before you keyword search it. If we're now going to say it's unreliable, well, then the whole disclosure exercise gets brought into question. So unfortunately, that proposition, I think, proves too much. So my learned friend makes a point then, I think later on in his submission, and this is the last point I'll make, about essentially the problems that this might cause for the claimants, about essentially how it might create difficulties for them. But I really do think this is a very simple issue and can be addressed very simply in answer. It's a question of, all things being equal, the claimants will receive all the information that they would receive from the native documents. They will be able to navigate through all the information that's usually visible or not visible in a native document, and they will get all the same metadata. They will not be worse off in any way. So on that side of the ledger, there's no plus or minus. We are at the same place. On our side, we've already articulated the risks of potentially not catching some embedded information, and we've already outlined the time and cost. And so I think the overriding objective weighs heavily in favour of our proposal.
Right. Thank you very much.
Thank you, my Lord.
My Lord, I'm so sorry to interrupt. Can I just clarify one point from my learned friend, because I must say didn't quite follow it. He seemed to be saying that we would be getting all of the embedded information in the images. So if for a particular file there was embedded information, I think the submission was quite clear that we would get all embedded information. And if that is
it was
relevant,
no,
I think I said all relevant embedded information. I think I said, and if I didn't, then I should correct that. The submission is you would be getting all relevant embedded information.
But I think the problem with that submission is that what he seems to be saying is that there is potentially a category of embedded information that they have not yet reviewed, that EY is saying you can't give disclosure of these documents without either reviewing it or converting the document to a format so that embedded information can never be seen. So
the embedded information is not visible on the natives, I'm told. And again, I mean, I'm addressing the point from principle in saying that if it's privileged, or if there's a reason to withhold production, then we won't supply the embedded information. If there's no reason to withhold production, we will. I mean, it's no more technical than that.
Well, your Lordship has my point. So what we're really talking about is a category of embedded information that they have not yet reviewed, that they don't propose to review, and will never be seen because it will never be visible on the image files. And that, in our submission, highlights the problem, which is they need to go back and check that in any event. Anyway, I'm sorry to interrupt, my Lord.
Anything more, Mr. Conte, on this point?
That's unless you have any questions, my Lord. Those are my submissions on this point.
I think I've got a grasp of it all. Thank you very much. In this case, the defendants seek a ruling which involves a departure from the ordinary rule in circumstances where the order by consent was that the parties would conduct disclosure in accordance with the rules for electronic disclosure set out in the White Book. Under Practice Direction 31B and the General Principle 4 and paragraphs 32 to 34, the ordinary rule is that disclosure should be given of documents in their native format. I do not have before me any technological evidence as to what would be the particular advantage or disadvantage of proceeding by that method, as opposed to allowing disclosure to be given by way of images instead. But the debate before me has centered on the question of embedded documents. Essentially, what is said by the defendants is that a further quality control would be required in order to ascertain whether or not there is embedded information which is either irrelevant or privileged or confidential. I am surprised by that submission because it appears to me that investigation ought already to have taken place. If what is being said is that there is an additional cost in doing this, that is a cost which should already have been incurred. In short, therefore, I see no good reason for departure from the general rule, particularly in circumstances where the parties had originally agreed to it, and no point was taken until April of this year. The claimants are going to disclose documents in their native format. As I say, I have not before me any relevant evidence as to the technological issues which may arise, and it may very well be that some of those put forward by Mr. Shivji are overblown. But it does seem to me, from my own experience, that the idea that you can produce Excel documents in anything other than native format is fraught with problems. So, in short, my ruling is that the documents should be produced in their native format, and if further work is needed in order to do that, and that incurs additional cost beyond putting them into an image form, then that should be done. I should say at once that it is agreed on all sides that where redaction is required, then images are the appropriate way forward. Very good. All right. That took quite a long time. So I rather hope that the other matters are going to be shorter, but let's see where we go to.
I'm wondering about a break, my lord, maybe because it's 10:30 for the transcribers, or?
Well, I'm very happy to have a break for a cup of coffee, but do the former liquidators documents fall into this category? There's a point here that's related, and I just wonder if Mr. Shivji has a proposition to make, whether he might make that proposition, and then you could consider it over the break.
That's sensible, my lord. Thank you.
Yeah, I'll be grateful, my lord. So this it's a pretty small issue. This we're talking about documents on Mr. Hayder's system, where he himself had built his own file structure for organizing his documents. This is not anything to do with the first claimant's documents. They have their own file structure. This is simply the post-liquidation documents that Mr. Hayder built on his own company's systems in order to organize his documents. And our concern is that if Mr. Hayder has built a structure that gives something away about his privileged investigation, so for example, if a folder said possible claims against Mr. X or Miss Y, that sort of information would be privileged and irrelevant to this litigation, because this litigation is not about the investigation, it's about the substance of the conduct. Now, actually, my learned friend raises quite fairly in his skeleton that the question of whether this problem actually arises should be examined on a case-by-case basis. It may not actually matter. And I myself have not had visibility of that folder structure, and we have not yet got to a point where we have turned our mind to give a definitive view on it. And so as I understood his position, essentially he suggested that we should go away and actually think about whether there is a real issue here or not. And if there is, we'll have to identify specifically which documents are impacted and see if we can agree that. And I think for my part, I would endorse that, because it does seem like a pretty microscopic issue. There is this question about whether this information can technically be privileged or not. I mean, all I'd say on that is this is a document. The metadata is a document under the rules, and data is capable of being privileged. So potentially one can imagine a scenario where there is a file structure that gives something away as to his thinking, and that would be subject to litigation privilege, and as a result, it would be privileged under the rules. But as I've said, my fear on our side is that we're dealing with this in the abstract, and it just may be that when someone's looked at it, they just think this really doesn't matter. So that was my proposal.
Your proposal is that you go away and think about it. I mean,
yes,
on the basis of what I've already said, you know, the starting point is you disclose in native format, and if there is privileged material that's embedded in one way or another, then you'll have to look at that, and if there is such material, then you'll have to disclose that it is privileged on the basis of a privileged log of some kind, and then the matter would fall for debate as to whether there was a genuine privilege that attached or not. To my mind, this, you know, for me to decide anything in the abstract at this stage probably doesn't make much sense. But I'll let Mr. Conte have a think about that over the break and see what he thinks about it when we come back. Unless you want to react immediately.
I've had a nod from my instructors, so I think the proposal is sensible, and I'm thankful to my learned friend for putting it forward. And I think this to some extent does marry up with the debate that we'll be having later on in respect of Mr. Ilie's documents, where and I thank my learned friend for this. We were able to narrow the issues, and we're in heated agreement that it is premature to deal with the question about an actual right to privilege, and we'll just be dealing with who should be reviewing the documents. I mean, this isn't something that should be handled in the abstract, so I agree. Doing it with concrete examples, it's much more helpful.
Well, it seems to me that the what's his name, Eisler documents, it's a very, very short point indeed. I mean, on the face of it, we've got the defendants claiming privilege. The claimants don't claim privilege. It seems to me that although it's on the first claimant's servers, the defendants ought to look at it and decide whether or not there is any element of privilege in it. But that's a provisional view before I've heard any argument on the subject. Well,
I can foreshadow now and reply. I adopt those comments as my submission, so I'll just move on to any other points I've got to make when I'm responding to that point, my lord.
It's merely that we've got 5 points I think to get through, and we don't seem to have got terribly far yet. But anyway, let's nonetheless take a break. Where are we now? 10:40 by English time. Let's take 10 minutes now, please. Thank you very much.
I'm grateful, thank you.
Right, where do we go next?
Thank you, my lord. We've just considered the batting order over the break, and I was hoping to propose a slight change in topics. I'm conscious of the timing, and it may be important to restructure the order to make sure we get through the more important topics, just in case we run out of time, which hopefully we won't. But in case we do, the topics are ones that perhaps are suitable to be adjourned off or to be dealt with on the 3rd. So I wondered if I could deal with the ACME documents next.
Yes.
So this item in the agenda is about documents held by Alpen Capital ME Limited, or ACME. We seek to summarise the relevant correspondence in paragraphs 69 to 76 of our skeleton. So to start, it may be useful if I took your lordship to some of the letters that form the backbone of this issue. In that regard, would your lordship please turn up HFW's letter to ACME? It's dated 1 November 2024, and it appears at 4147 in the bundle.
Well, again, I'm rather hoping this point can be taken relatively shortly.
Yes, I mean, this is the only... So, yes, my lord.
There's got to be a proper follow-up to this, self-evidently, to make sure that everything's coming forward. You're looking for a witness statement that sort of covers the ground.
Yes, and
the real question, as I say, is simply whether or not there is more material that ACME has that ought to be forthcoming, and how therefore to put pressure, if any, upon Altamimi and ACME itself.
Yes, just to make clear, and in the interest of narrowing the issues, if you turn up the draft order, that's at paragraph 4600 of the bundle, 4600.
Yeah.
So we don't press 12.2 because we accept that very late in the day, I think it was the morning, in the morning here in England yesterday, further information was sent through, including a witness statement and Braganza 12. And so we don't press 12.2. The only two parts of that order that we press are 12.1, the statement that should be filed in 7 days should explain in detail why the claimants did not request ACME to put in place a litigation hold. And then 12.3, inform the defendants whether the claimants have received any response from Altamimi & Co. to their letter dated 11 July. And if so, exhibit a copy of the respondents. And if not, the statement should outline the further steps that the claimants propose to take in order to elicit a response, providing a deadline for each step. If your lordship is familiar with the correspondence, I won't take you through it, and I can just move to my submissions if your lordship would like me to proceed in that way.
Right. I'm not sure I need to hear from you in one sense, because it seems to me that the practical question is how to extract anything further that there may be. I understand you want to criticise the claimants for not asking for anything until November 2024. And you say they haven't pursued this with due diligence even since then. I understand
Yes.
all.
And as an aside, I mean, the liquidator does have powers to retrieve documents beyond normal litigants. And so you have a situation where retrospectively, we want an explanation about the litigation hold looking back, because it will make a difference, or it could potentially make a large difference depending on the content of ACME's policy and what that holds, and whether that's to the same standard of the document retention policy or the litigation hold that was requested in November. So there's a real question about have documents been destroyed or deleted pursuant to ACME's policy that would not have been destroyed or deleted had the claimants notified ACME of the litigation hold at an earlier period in time. So we say we're entitled to an explanation about that retrospectively. And prospectively, we now do need to get on with it. And the short point is this: as you say, there was a 5-month gap between the previous letter and the last letter. We haven't heard, I'll wait to hear what my learned friend has to say, but haven't heard an explanation for that 5-month gap. But we're now at a stage where time is of the essence. Disclosure deadline is looming. It's in September, and they really do need to get on with it. And if ACME aren't going to respond, then we're in a situation now we need to be updated. We need to be provided with notice of what's actually happened, and if not, we have to decide what to do. Now, I'd just like to address you on one point I think you have my point about the relief we're asking for and why it's important. But I think it is quite important, if I may, just to deal with a couple of points in my learned friend's skeleton about how there may not be any documents of any importance, if I may.
Yes. Can I ask first, do you say these documents are actually in the claimant's possession or control?
Yes, and they in their letter, the one that I was going to take you to, say that to the extent the documents were created while the employees and directors were directors of the claimant, then they form part of the company's books and records. So, I mean, they've actually asserted that in correspondence to ATCO.
That would indeed be my understanding. So the real question is the practical one of getting hold of this stuff. I mean, I don't want to cut you short, but in a sense, I want to hear from Mr. Shivji what he proposes to do, and then you can come back and say why that's inadequate or exactly what order you want. I mean, I understand entirely the criticisms that you make and why you want a witness statement in relation to it, but the more immediate question is how to get any documents if there are any to be had, and that's outside your hands. And so it's the burden's on Mr. Shivji to tell me what he's doing about it to produce documents that are in his possession or control.
I'm grateful, my lord.
Yes, Mr. Shivji.
So my lord, your lordship rightly asked the question about whether these documents are in our control. I think it's important just to step back for a moment. We have rights in relation to documents created by our directors and our employees. But ACME is neither of those. It is a third party whom our employees used their servers in relation to sending some emails. So I think it's just important to remember that our rights are against our people. Those are the only documents that we have control of. We have no rights per se against ACME. And ACME are entitled to turn around and say, you don't control us. We have no legal obligation to give you anything at all. Now, I recognise that in relation to our people, that those are documents in our control, and that we should continue to press. And I understand the concern expressed that we've not been swift enough, and I also recognise that there is a September deadline coming along, and that we, as a result, need to act now with expedition. My submission to you would be, we've heard your lordship's remarks, everything you've said about this. We know that your lordship would expect us to do more, and we will have to demonstrate to your lordship that we are doing that. And that's something that your lordship will then see at the next hearing in September when we're back before you. We, at the moment, Tamimi are not responding to our correspondence. We've written to them again this week. We set a deadline for response ahead of the deadline for skeletons today, in the hope that we would be able to update your lordship. And we explained to them that the deadline that we had set was so that we could update your lordship. And that letter is at 4504.
But let's just assume lack of cooperation.
Yes.
What then are you going to do?
Well, there is a limit to what we can do. But our power exists in relation to the people that I have identified. So we are and my learned friend said that, well, we have wide powers, but those powers are limited by their jurisdictional reach. So I'm not in a position today to say, yes, we will be making an application, but I hear your lordship, the sense of what your lordship has said, which is that you'll go require some persuasion that we've acted properly and done everything that we properly can. And so we will have to consider that question. If there is, it looks like we're in a world where there's no cooperation. We'll have to consider whether we can now properly make an application against the individuals. But there is, and I don't hear my learned friend saying otherwise, there is a geographical limitation to those powers. So we can't exercise those powers against by compulsion against persons overseas who don't want to cooperate.
Well, I think I'm going to have to hold your feet to the fire here, Mr. Shipji, because it seems to me that I've got to set a deadline,
yes,
by which you come back to the court with evidence in the form of a witness statement, and exactly what that'll have to cover we can discuss in a moment as to whether it covers each of the elements that Mr. Conte seeks. But above all, what it must show is what you're doing in order to get the documents such as they are, which everybody accepts must exist.
Well, they may. I'm not sure.
Or may once exist.
Well, I'm not. So obviously, we know that there are emails from their server, and we've not been given emails from their server.
Exactly.
But I don't actually accept. I understand why the defendants are pressing for this, and we've pressed very hard on their disclosure, and they're looking for points to press on ours. I don't actually at the moment understand what at its heart the relevance of this material is, because if insofar it's material that involves any discussions between the board of the claimant, then we've got copies of the claimant's own emails and the defendants have copies of their emails. So it seems to us it's highly unlikely to illuminate board level discussions that are not captured by another repository. So what we're really talking about is internal discussions between these individuals that didn't involve the wider board. And on our case, the conspiracy that we complained about was something that was done in secret without the whole board knowing. So these documents are not going to go to the conspiracy. And there is no suggestion on my learned friend's side that somehow these these individuals were notified. And if they were, that would be picked up in the defendant's own documents. So we don't accept that this is actually a illuminating category of documents, but I do accept that for documents that are within our control, we should have properly investigated that. I fully accept that. What I would suggest, my lord, is can I just look at the order that my learned friend wants, because he wants us first to explain in detail why the claimants didn't request ACME to put in place a litigation hold until November 2024. That is actually wrong-headed because it focuses on the wrong individual, the wrong person. The point is about the individuals over which we have power control. And in relation to those, we have made inquiries in the past. Those inquiries were largely by Mr. Hayder, because until last year, it was Mr. Hayder who had conduct of this. And we doubt at this stage that there is any value in my client, Miss Eason, trying to piece together exactly what Mr. Hayder did at each point and what he was thinking in order to illuminate this question. As we understand your lordship's position, you just want to see that we've got on with it and we have done our jolly best. And so my suggestion to your lordship would be, rather than compelling us to provide a witness statement explaining how we've got here, we would suggest that the efforts are better deployed actually working out where we go from here and persuading your lordship that we really are doing our job and pursuing all sensible lines of inquiry. And maybe, my lord, the best approach is to say that within 14 days we will give a written update to your lordship by letter to explain what we're proposing to do next. And I would say that was a better use of resources than some witness statement, there's some forensic exercise over why Mr. Hayder did what he did in the past.
Mr. Conte?
Thank you, my lord. So can I address a couple of points? So my learned friend said he didn't understand what the relevance of this material is. Well, this is strikingly similar to a debate that we had at the September CMC, just the shoe was on the other foot. So it's common ground that very prominent figures sent emails about the first claimant's matters using their Alpen email accounts, and that includes Mr. Walia, who was the first claimant CEO, Mr. Kerman, director of the first claimant, Ms. Ahmed, director of the first claimant, and Mr. Limay, who was at one point the first claimant's company secretary. It's also common ground that Alpen representatives were responsible for important finance functions within the first claimant. And in addition, various key documents the claimants rely upon in their pleading were created and circulated from an Alpen email account. I won't ask your lordship to turn it up, but at paragraph 43, there's an email from dated 16 January 2014, where Mr. Limay, a then representative of Alpen and BCA's company secretary, sent an email to Mr. Carton attaching a spreadsheet entitled Winding Down Options, and that was sent by or from his Alpen email account, and that's relied on quite heavily by my learned friends since then. So the point is it's quite important, not just what the materials contain, but who are the authors of the materials or the senders of the emails. So moving to relevance, well, again, I query the wisdom of my learned friend's submission given what happened in September. You'll recall at the 23rd September CMC, you observed that in many cases valuable information will be contained not in the formal documents themselves, but in the notes that a director may make on them. So if I can ask you to turn to page 976 of the bundle.
Well, Mr. Conte, I'm entirely with you on relevance. You don't need to address me on relevance. The real question is what to do about all this. I don't have any doubts that this material ought to be produced if it can be.
Yes.
So the question is, do it. And let me tell you what I'm thinking, and you can tell me whether this is adequate or not. I'm thinking that within 2 weeks, and it has to be a deadline of that sort of time, the claimants should file a witness statement saying exactly what it is they're doing and how they propose to get these documents on the basis of lack of cooperation, if there be such, from ACME. And indeed from those individuals concerned. So we need to know what they're going to do. I'm quite happy that they should include, to the extent that it's going to help anybody, what appears in 12.1, 12.2. Yeah, that's really what it comes to. So I think it basically, I'm saying subject to timing, because you want it by the 24th of July, and I think that's just a bit too. If we say 2 weeks from today, you don't need 12.3 anymore, but you do want 12.1, 12.2, and 12.3b. Is that right?
Sorry, no, it was 12.2 that we weren't pressing. So we want 12.1. And 12.1 and 12.3 were the two that we were still pressing.
I thought you had got we'd seen a response to the 11th of July letter, or is that, am I wrong?
No, sorry to interrupt, my lord, but we haven't received, I mean, 12.3 we have no issue with, so right. I'm very content to provide that. Can I just, on 12.1, I hear what your lordship says, but we are
you can say,
my lord, to speak.
You can say what you can say, and that's all. I mean, at the end of the day, you know, if you failed to do what you ought to do, well, there we are, and no doubt blame can be attached. But it seems to me you ought to provide whatever explanation you can.
But sorry, my lord. on that point, can I just flag this though, that what I'm reluctant on our side to do is to spend much time at this stage with us poring back over Mr. Hayder's records to work out what he was doing and thinking. It just, if it's going to be directed at anyone, it needs to be directed at Miss Eason, and it can only relate to her period in office, would be my suggestion. And in the first instance, I'd suggest that our efforts are directed for actually progressing this, rather than the archaeology of the past. I don't mean to press it, my lord, but it's just, you can imagine how much time we'll waste doing that. And I would suggest that that isn't something that is important or needs to be done in the next couple of weeks.
I mean, if they'd like to give...
Remind me when Eason came into office.
She was appointed end of April 2024.
Right.
My lord, one way through it may be, if my learned friend's objection is about timing, we could have that witness statement within 21 days. The witness statement covering that point, and they could have an extra week. So they expedite the more important matters and they can have an extra 7 days. The idea with the amount in dispute in this case, that this is going to cause consternation and cause an incredible amount of cost relative to the amount incurred, I find difficult to see as a really strong argument. So I think, my submission...
I see all of that, Mr. Conte, but at the end of the day, how is this going to advance matters?
Because
at the end of the day, you say the previous liquidator, failed to do what he ought to have done. How's that going to help anybody?
Well, depending on what they have done and depending on if we are able to see the difference in policies, if the documents have been deleted, we may have to make an application to retrieve some documents from someone else. It will be helpful to know whether the repository is a full repository or not. And if it's not, then we may have to make applications consequent to that.
I'm sorry, I'm not understanding that, Mr. Conte.
It would be helpful to know if in due course we find out that the document retention policy that's being applied is very different to a litigation hold. There may be applications that need to be made consequent to that.
And what would those be?
We might have to make an application to see if we can get the documents from someone else, for example.
I think my learned friend might be misreading his own order at 12.1. 12.1 does not relate to what ACME did and what its retention policy was. It's an obligation on us to explain why we didn't ask at a different point. And that was my objection. It doesn't actually sound like my learned friend has an answer on that. It sounds like what he's interested in is what ACME's policy was. And I understand that. And when we go away to work out what our action points are, we will need to consider that. I mean, the only thing I would say is I don't understand my learned friend to be saying that we should be making an application against ACME. And he is, I can understand his point that we can pursue the people over whom we have control, but not the third party. And of course, it's open to him to make an application against the third party, and it always has been as well. So if that's what he wants to do, he can make an application against ACME. What we will go away and consider is whether we need to make an application against the people over whom we have control. And I hear with considerable force your lordship's points that you expect to see some action on our part, and I've got that well in mind when we look at what we're going to do.
Yeah, because if for example there's no action that is effective as such in relation to what you can do, then one party or the other may want to make an application for third-party disclosure against ACME. That's the only other way forward, and if that's going to be done, it's got to be done in good time. So what I'm going to order, having heard it you all, is that within 2 weeks, you file and serve a witness statement that deals with the points that remain, and as far as 12.1 is concerned, explains why the current liquidator did nothing until November, and if that requires saying, well, I didn't think about it or whatever until that point, so be it. If we have to go back beyond that in due course for other reasons, maybe we'll do that. But it does seem to me the real issue is whether or not someone is going to have to take an application out for third-party disclosure at some point. So, yeah, it's 12.1 to the limited extent I've indicated, 12.2 and 12.3, yeah. All right, 2 weeks. Right, what's next?
My Lord, I wonder if we could deal with Mr. Ilie's documents, because it's a narrow point. You've already made an observation. I thought maybe it might be useful for us to knock that off, given it should be quite short.
Well, let me hear what Mr. Shipji has to say in the light of my indication. The way I see it is, well, go on. Yeah. You
so
know.
I know what your lordship's going, and I'm grateful for the indication before the break, and we've taken some instructions which I'm just reading. So just to sort of explain that, because I'm going to essentially agree with what your lordship says, but subject to just a couple of reserving my rights on a couple of points. Mr. Eisel was seconded to us, so he worked for us for the relevant period. He we understand the concern. We raised the concern about the possibility of privilege being held in the favour of the fourth defendant, but Mr. Eisel was performing a legal function for us. So it is also possible that there is material there that we have privilege over. Now, I'm not, the practical way forward, we say, is fine, the defendants can have these documents for review. If when they start reviewing it, they do come across documents where they think that the privilege is owed in favour of my client, they will have to stop at that point, because they ought not to be reviewing that. And in those circumstances, it would need to go off to a third party. I mean, what we'd proposed, which is what happened in the BBGP case, which I acted in, is that an independent lawyer is appointed just for this job. And we were actually going to use a junior member of the English bar. With not making any aspersions about the cost of everybody, they are very good value for that sort of function. They'll do it, as you lordship will know, they'll do it very well, they'll do it economically, and they'll do it quickly. So that's what we had in mind. That is still an available option. If it turns out that there are competing privilege arguments in both directions, that is the only solution. And the other point is that there may well be a question of principle, is that even if the documents are potentially privileged in favour of D4, there may be a question about whether what Mr. Eisel was doing is something that can properly attach privilege because of the nature of the conduct and the policies in place. And I'm just going to reserve my position on all of that. We couldn't hope to argue about that now. That's for another day. So, I mean, subject to your lordship's view, we were content subject to those caveats.
Yes. Well, it seems to me that the likelihood, in fact, of privilege arising in favour of the claimants is very limited indeed. I don't think it's actually huge in relation to the defendants either. But in the circumstances, I think the documents should be made available to the defendants for the defendants to peruse. They're conscious that if they come across documents which could potentially be subject to privilege on the part of the claimants, then at that point they have to disclose the fact, and we will deal with that as and when it arises. So I'm going to say if they come across that, they should immediately apply to the court and let the court know, and the court will then have to involve a third party, which, as you say, won't actually be enormously expensive in the circumstances, but does mean someone starting from scratch who's then got to understand the basis of the litigation. I don't know if you can agree at a form of order that encapsulates that.
The only helpful indication might be about timing of when the documents are transferred. Obviously, the sooner the better. I don't know whether my learned friend has a view on that, but perhaps within 7 days.
Does that sound feasible?
I have a technical answer, but I will tell my team that we just need to crack on and hand it over as soon as we practically can. So I don't know whether 7 days is feasible, but it's that sort of timescale. We're not going to drag our feet. We'll make the arrangements.
I'll leave that for you to agree between you in the form of the order.
Great.
Well, thank you, my lord. Perhaps we could deal very, very briefly with the ATE policy point. Again, my understanding from your lordship earlier was you'd read the correspondence, and so perhaps I don't need to take you through the correspondence and you're aware of the issues, but please let me know if you're not. You'll see the proposed order at page 4601 of the bundle, essentially, all we're asking for is a confirmation of two pieces of information that we understand shouldn't be controversial, because it tracks what HFW have said in correspondence, and we'd like that within 7 days. It's the date by which the claimants say they will be signing the revised endorsement has moved around somewhat, but the latest indication was that they will do it by 31 July. So we've simply said we'd like a copy of the endorsement, which they say they're happy to give by the 1st of August. I don't think, I'll wait to hear what my learned friend has to say, but in my submission, neither of those 2 points are controversial, because they do track what the claimants have said in correspondence.
So just on that, I think the most important thing is his paragraph 16, which is that they get the endorsement by the 1st of August. That's fine for us. The endorsement will answer all their questions about the information. I think paragraph 15, what my learned friend seems to be saying is that he's already content that we've provided the information. So I don't understand why we need to provide it again. And I would say in any event, they're going to get the policy the following week. So I would delete his 15, and we're happy to agree to his 16.
Mr. Conte?
I think we can agree to that, as long as so just to be clear, 16 stays, 15 goes.
Yeah.
Yes.
Yes,
So,
that makes sense.
I must say, given the amount that we've agreed between Mr. Shivji and I, perhaps my learned leader, Mr. Montague-Smith, has been the problem all along, and left to our own devices, Mr. Shivji and I have managed to just agree on multiple points, and everything seems to be much more efficient. So I'm very grateful. So at this point, it might be helpful to move to keywords. Miss Bell will be dealing with keywords. So can I perhaps have 2 minutes just to switch positions with her, and then she can come online?
Yes. Who is actually going to be instructed to appear at this trial when it happens? We have a variety of different leaders who've appeared or were intending to appear at one time today. Have decisions been made on that? I mean, the only reason I asked Mr. Conte is this, that it helps in my experience to have someone who's involved, who's going to run the trial in relation to the interlocutory spats, because they can form a view as to whether these things are important or unimportant. So,
yes.
We've had so far Miss Howard, Mr. Montague-Smith, a mention of Mr. Lakshman, yourself, and you're now about to hand over to Miss Bell, I think. What's going to happen at the trial, assuming the trial happens?
Mr. Montague-Smith will be appearing at the trial. The only reason he's not appearing today is he unfortunately had a diary clash, but he will be appearing at the trial. He's briefed for the trial, and barring anything unforeseeable, he should be appearing at all the major interlocutory hearings.
Yes, all right. Well, I shall make an inquiry at the end of this hearing as to what is actually going on in terms of in-principle settlement and non-agreement, which you may or may not be able to answer. But I'm just making that inquiry because it obviously is significant from the court's point of view in setting aside a period of time, and indeed from my personal point of view in setting aside a period of time, not just for the trial, but for pre-reading and judgment writing. So as long as you're conscious that that's an inquiry I'm going to make, and are prepared to give such answers as you are able to give without breaking any professional duty or any other sort of duty, that would be helpful.
Understood, my lord, and more than happy to. I may, after you ask the question, need a moment to consult with my instructors, but of course, if I'm able to answer the question, I absolutely will.
Well, I say it's just making an inquiry of that kind. So
yes.
You can tell me whatever you're free to tell me, and where you're not free to tell me, just tell me you're not free to tell me.
Yes.
Anyway, you've got some time out while Miss Bell deals with things, so you can explore that with those instructing you.
Yeah, I'm grateful, my lord. So I'll now turn off my camera and the microphone for just 2 minutes.
Yeah.
My lord, just while they're making that changeover, I sort of I understand the basis for your lordship's inquiry. I mean, we fully understand that the court needs to know if the case goes, or is highly likely to go, your lordship will need to know as soon as possible, because it has a very substantial impact on the court's diary, which is reserving a lot of time for us, and we're very grateful for that. I mean, the discussions are without prejudice. We have a professional obligation not to tell you about the detail of those discussions, so obviously we can't go into that. But it may be, lordship, that actually what your lordship can order is that at various points there is an update given to the court on what can be said openly. Now that obviously won't trespass on without prejudice, but it may be that the parties then have an opportunity to agree a formal warning to give your lordship an indication. And I have been involved in other cases in the past when the parties have said to the court, we haven't got anything firm to say at the moment, but we can give you an indication, and that may be something that's useful to your lordship. But as I said, we're not able at all to go into without prejudice, so I can't say anything about where we are and where it's going. But I can say that, I think, on what the court is able to direct and what has worked in other cases.
Yes, but the unusual feature of this case is that the court has been told that there was an in-principle settlement agreed on the 19th of May. And, you know, to be told that is unusual in the context of without prejudice negotiations. But I will understand if that's all you can tell the court, and it's come to nothing so far. Well, that's where we are. Yeah, all right. Miss Bell, you're taking over the reins for a bit.
Yes, thank you, my lord.
So where are we going next?
My lord, the remaining issues relate to search parameters and keywords. And as I see the issues, they fall into two broad categories. The first is the claimant's keywords to be applied to its hard copy documents and former liquidators' working papers. And secondly, whether the defendant should be obliged to apply additional keywords proposed by the claimant to the fourth defendant's hypersuite files, the fifth defendant's W drive, and the fifth defendant's hard copy documents. There are two further matters relating to the searching of audio recordings and fields to be extracted from the fourth defendant's Avaloq database. The defendant's high-level position on those two matters is that the parties ought to engage in further correspondence to resolve the outstanding issues, and the defendants intend to take instructions, particularly on the Avaloq database. And to the extent those issues can't be agreed in correspondence, they should be decided at the CMC listed for the 3rd of September 2025. I think in the batting order, Mr. Shivji was to go first on the issue of keywords, but I'm also happy to introduce the issues and make submissions.
Well, I think I'm fairly up to speed on what the issues are, having read the material.
My lord, sorry to interrupt.
Yes, go on.
So I don't criticise my own friend for it at all, but we had agreed a running order, and the running order had been designed because it gives your lordship an insight as to the stages at which the exercise is at. And ahead of this in the running order was my learned friend's proposal on deduplication that your lordship mentioned earlier, and also the pseudo-anonymisation protocol. And I don't know if my learned friends are pursuing those. If they're not, that's fine. They can be put to one side. But it seemed to me that they provide some quite useful context to these issues that my learned friend has now raised, and they were ahead in the agenda. So I don't want to take her out of her flow. She is right, actually, on this issue anyway. I was meant to go first. But can we just ask whether she's still pressing for those orders? And if she does, I'd suggest she deals with those first.
My lord, we are still pressing for those issues. Rather unhelpfully, after the switch of seats, Mr. Conte is dealing with those two particular issues. And we would suggest that the keywords be dealt with first, and then the practicalities around production of documents in relation to deduplication and pseudonymization can be dealt with sensibly afterwards.
They're not interrelated in any way.
Not as we see the issues, my lord, no.
No.
Well, my lord, I think I see it slightly differently, which is why parties had agreed a different. I mean, it was common ground what the sequence would be, but the reason it matters is because essentially the answers are on these keyword. So there are two categories of keyword searches. There are the claimant's proposals. We've made those proposals. My learned friend doesn't deal with them at all in their skeleton. And so I actually don't know what their position is. We actually thought it was agreed because they hadn't dealt with it. But if my learned friend's saying they're not agreed, then we'll have to hear about that. And then in relation to their disclosure, we're talking about a small number of repositories of documents where the scale of the search is quite limited, and it depends on the repository and the nature of the keyword. But they're quite limited exercises. We would say that it's important context to that to understand the exercises they are proposing in terms, in particular, of the pseudo-anonymization, because what they have got planned there is a very substantial full review of all of the documents that they are going to give, which we say is completely unnecessary. And if we're right about that, and that just simply doesn't need to be done, that will save months worth of time. And this small skirmish about keywords is a drop in the ocean and can be easily accommodated with the resources that would be freed up on pseudo-anonymization. So I would say that it is relevant context for your lordship to understand what they've still got left to do. And if they don't have to do the pseudo-anonymization piece that they envisage, that is highly relevant to actually whether or not these keywords matter at all, or whether it's small beer. So that is why we agreed with them the sequence, and I would still suggest that is a more sensible sequence.
My lord, our view is that the pseudonymization doesn't impact what searches have to be done in the first place. That relates to keywords, which is why we've approached them separately.
Well, I understand, but it does seem to me that the pseudonymization, whatever the appropriate phrase is something that is going to take up a lot of time and effort if it's ordered. So probably it does make sense to deal with that first. So I think probably, Miss Bell, I'd like to hear from Mr. Conte before hearing from you, if you don't mind.
I don't mind, my lord. I'll switch back with Mr. Conte.
Thank you very much.
Thank you, my lord.
Just when you thought you could slope off for a quiet few minutes, you're back. But I think the plan is that you deal with pseudonyms, whatever the appropriate expression is, but be using pseudonyms.
Yes.
And the deduplication point.
So we might just revert to the order then, and I'll deal with documents held by both the fourth defendant.
Bear with me for a moment. My battery seems to be doing things. Okay, we're all right now.
So shall I deal with then copy documents held by both the fourth defendant and the fifth defendant? And subject to Mr. Shifke, I might as well also deal with copy documents held by the fourth defendant and the claimants, because it's both copy documents that we are dealing with. So starting with the copy documents held by the fourth defendant and the fifth defendant, we seek an order that where the fourth defendant and the fifth defendant both possess a copy of the same document, only the fifth defendant will disclose a copy of that document. And that's paragraph 2 of our revised order. That's at 45991. Now, we note in paragraphs 22 to 23 of our skeleton that there are essentially 4 reasons why the court should make the order sought. First, our proposal is in the spirit of Rule 28.3, which provides that a party need not produce more than one copy of the same document. We say this reflects the fact that it is not reasonable or proportionate for parties to disclose multiple copies of the same document, even where the metadata may be different. So, for example, if multiple custodians hold the same document in different places, each of those documents will display different metadata. However, a party is not required to disclose each copy of the document merely so that the other party can see when and where each particular custodian stored the document. Second, and ordinarily,
as long as it's clear, you say, that where it matters, that both had copies of the same document.
Yes. As in D4, as in the fourth and fifth defendant, yes.
Yes, indeed. Okay.
So my second point is this. Ordinarily, D4 and D5's documents would be uploaded to the same disclosure platform, and Ds would apply deduplication software, and only one copy of the same document will be disclosed. The only reason in this case that that is not happening is because the fourth defendant is in a different jurisdiction, and consequently the fourth defendant's documents are being reviewed on a different platform. That is a matter of mere happenstance. We say the circumstances don't provide for a principled basis for treating this case differently. It remains true that in principle, it's undesirable that duplicate documents should be disclosed, and it should not be merely because of the chance that you're dealing with 2 defendants in 2 jurisdictions that you get a different outcome. There's not a principled reason for drawing that distinction. Third, the defendants understand that most of the documents in this category are likely to be emails exchanged between employees of the fourth defendant and the fifth defendant. So I've been instructed that, based on a first-level review of 938 copy documents identified as relevant, 893 are emails and only 45 are other documents. So I'll repeat the figures. 938 total documents, first-level review, 893 are emails and only 45 are other documents. What
sort of documents are the others then?
Can I have a moment, my lord?
Notes of meetings, memoranda?
I can't give you an answer to that at the moment. We'd have to ask.
Okay.
But I would assume, and again, I'm assuming this, that it's Word and PDFs, just based on the review to date. As regards the emails, the same metadata will be provided, that is, field, subject matter, date sent and time. Same metadata will be provided from both the sender's original email and the recipient's copy email that's received. So if I send Miss Bell an email, you effectively have 2 emails. You have the copy that effectively was my copy that I sent to her and the copy that she received. Both of those will have the same metadata. It's looking at 2 different documents, but effectively the same thing through 2 different angles. So in short, disclosing the duplicate document will not provide Cs with any additional metadata at all. Finally, the benefit of this proposal is that it reduces the number of documents potentially subject to foreign legal restrictions, and therefore reduces the scope for a costly and protracted dispute between the parties on whether such restrictions would apply. So notably, in paragraph 9.1 of my learned friend's skeleton, they propound only one argument as to why the fourth defendant and the fifth defendant should have to disclose the same document. They contend that, where otherwise, the claimants would be deprived of relevant file path metadata. But we say, 2 points, that's a tail wagging the dog. The question is whether a party must disclose a document. Disclosure is about documents, not about metadata. It's primarily about documents. And it's only for parties required to disclose a document that they're required to provide the metadata. You can't decouple. In this case, if the fourth defendant is not required to produce duplicate documents, then it follows that the fourth defendant should not be required to produce the associated metadata for that document. In any event, as mentioned, most of the documents in play here are emails for which file path metadata is simply not relevant. Lastly, it's also notable that the claimants have made a similar proposal in respect of duplicate documents. So would your lordship turn to page 4553 of the bundle? That's paragraph 14.2 of my learned friend's skeleton. Would your lordship please read that paragraph to himself?
Yeah.
So as we understand it, what the claimants are proposing in that paragraph is that where documents are duplicated in the first claimant's servers and the servers of the former liquidator, the claimants propose only to search and disclose them once. So our proposition there is quite simple. The claimants can't have it both ways. So just moving now to the other part, or the section of this debate, and that's about copy documents held by both the fourth defendant and the claimants. On that, would your lordship please turn to paragraph 3 of our revised draft order, and it appears at page 4599 of the bundle.
Yeah.
Sorry. So as you will see, this regime deals with the MD5 hash numbers. And in summary, what the proposal is that the fourth defendant will send to the claimant a list of MD5 hash numbers which refer to documents which should be in the claimant's control. The claimants will then confirm which specific documents are in their control. And then paragraph 3.3 is basically the simple proposition that the fourth defendant won't be required to disclose those documents. So I pause to note the timing of 3.1 and 3.2. 3.1, the provision of the MD5 hash numbers, is the 12th of September 2025, and 3.2, i.e. the time when the claimants need to come back to the defendants in writing, is the 17th of September 2025. We appreciate that that is close to the disclosure deadline, but we say that's necessary because the later in the procedure that this process takes place, the more accurate the list will be. So it will reflect the output of the defendant's second level review, which will in turn save time and costs for both parties. So there are 3 important points I would like to make here, if I may. First, there's similar points here to those that I just made in respect of copy documents held by the fourth and the fifth defendant. It does not assist the parties in the court for multiple copy documents of the same document to be disclosed. The second point is, in the case of documents that potentially are in the possession of the fourth defendant and the claimants, EY have confirmed that they are identifying documents solely on the basis that they are emails in which either the sender or one of the recipients has an email address indicating that they are a director or an employee of either the first claimant or ACME. In particular, the relevant email addresses are those that have a Sarasin-Alpen with a hyphen address or an Alpen capital email address. Therefore, all of the documents in this category are emails. As a result, even if the fourth defendant is required to disclose a copy of a document that the claimants already hold, the claimants will not receive any additional metadata. Finally, as was the case with the previous issue, the defendant's proposals will reduce the documents that are potentially subject to foreign legal restrictions and therefore also reduce the scope for a costly and protracted dispute on that point. One final point that I must address, and it was one that my learned friend raised in his introduction. It's also set out.
Your third point, Mr. Conte.
The proposal will reduce the prospect of documents which are potentially subject to foreign legal restrictions being produced. And that will save time and cost, and because it will avoid potential satellite disputes. There's one final point that I must address. It's in the skeleton, and my learned friend raised it earlier. So in paragraph 9.2 of my learned friend's skeleton, he says that the defendants have not determined whether foreign legal restrictions apply as part of their first level review. And he says, I quote, "This cries out for an explanation." So the explanation, in truth, is rather simple. The defendant's first level review was carried out by a third-party e-disclosure provider, Lineal. You'll recall that Ms. Howard mentioned that in one of her updating witness statements she provided to the court. And further, in order to keep costs down, that first level review team was staffed with paralegals and other individuals who had not completed their legal training and therefore were not equipped to identify and resolve complex issues of foreign law, including Swiss law, and issues regarding mutual legal assistance. So accordingly, Jones Day, with the input of appropriate legal counsel, are to consider the issues when conducting the second level review and finalising the defendant's disclosure exercise.
Well, that is a bit surprising, Mr. Conte, isn't it? I mean, you know, this question of banking secrecy has been around for a long time. We've had evidence on it from Swiss lawyer and so on and so forth, which, in my view at the time, was not adequate to deal with questions of waiver of customer banking secrecy and so on. As matters stand, I don't have any evidence that shows that there is any relevant and valid secrecy law of Switzerland, Luxembourg, or anywhere else at all. And that was the view that I formed, I think, and expressed at a previous CMC. I'm surprised to find that you haven't yet determined what you say may be subject to such potential secrecy laws.
I'd rather not. Sorry, my lord.
No, well, do you want to say anything about that?
There is an explanation. I've provided one about the first level review. There's also an issue linked to the settlement discussions that went on, but I don't feel like I'm in a position to be referring to that. All I will say is there are reasons why the procedure hasn't moved in the way that it may otherwise have moved. And if an application to be made, it'll be made as soon as we're in a position to do so.
Yes. This trial is booked for when? Remind me.
September 2026.
Yeah. Yeah. Yes. All right. Anything else you want to say at this stage?
It's only
So the one last point is that I should note that the claimants have agreed that if there are any issues with foreign legal restrictions, they're the ones that we can withhold. So the debate is not actually about, on this issue, it's not about the foreign legal restrictions box, it's about the remainder.
No, I've got that point, don't worry. Yes, all right. Well, Mr. Shipji, can we just deal with this duplication point first?
Yes, my lord. I mean, it's helpful to hear what my learned friend had to say. Some of what he said was new and hasn't been explored in correspondence, in particular the submission that really what we're talking about is duplication of emails. It does seem to us that where there are genuine concerns about duplication that can be avoided, they just need to be discussed and agreed between the parties. I mean, if my learned friend is right, and as I said, I haven't seen the data on this, that actually what we're talking about is identical duplicates of email. So the email might have been sent around 5 people and you've got 5 copies. Then there obviously needs to be some sensible way of avoiding producing multiple identical documents. But but it's very important the baby is not thrown out with the bathwater. I explained to you the sort of thing that I'm really focused on, which were things like, as I said, the hypothesis of a relaunch plan memo, and that might have gone around different people. I mean, that's obviously a hypothetical example. I'm not suggesting that that's where we are, but one can imagine, given what we know about the facts, that sort of possibility it seems quite likely. There, under the rules, they would be obliged to provide each custodian's copy of the memo. Now, my learned friend says that isn't required under 28.3, but he's wrong about that. He took you to 28.3.
Yeah,
which says You understand that document, he's just wrong about that. The definition of document 28.2 makes it clear that in the circumstance I posited, they would be different copies of the document. So that's really what we're interested in capturing. I must say that having heard what my learned friend has to say today, my suggestion would be that your lordship doesn't make the order that they want, any order that they want, that actually there is then discussion between parties as to genuine areas of pure duplication. Like if my learned friend is right, that really what we're talking about is, in principle, primarily emails, and there is a world in cutting the email population down, that seems eminently sensible. Now, I'm told by my team that it becomes a bit complicated when you're talking about attachments and attachments of attachments. But that seems to me that it's a sort of thing that technical teams can talk about. If there is a way of cutting through stacks of identical emails, then it helps everyone to do that. And my suggestion would be that your lordship sends us a way to go and do that. But conversely, what my learned friends cannot do is avoid having to tell us where they've got multiple different versions, essentially, of documents with different custodians that would be critically relevant to the forensic exercise. And then the reason I gave you the introduction on the foreign law restrictions is because we have been told throughout this litigation that there were these concerns. They've never been properly demonstrated, and your lordship has ruled on that on numerous occasions. No further evidence has been given. No review has been conducted of these documents, and time is continuing to pass. And your lordship is right to have a look at how much time we've got between now and trial. My experience with this letters rogatory process, and I've acted for Swiss institutions in the past, is it does take time. It really does take some considerable time, and you just have to get your application in. So what won't wash is for the defendants to do nothing and at the last minute withhold from disclosure reams of documents because they say they're subject to some foreign law jurisdiction that your lordship has never ruled on. That wouldn't wash. So they are ultimately storing up a problem for themselves because they will need to give these documents on the disclosure deadline. And if they don't have the letters rogatory permission from the Swiss courts, that's their lookout. It's being done for their comfort, not for ours. So I mean, I've given them all of those warnings. But I mean, in terms of the duplication, I'm agreed in principle that I don't want this to be a waste of time. But I just don't think your lordship can really navigate sufficiently through the detail of the issues to make a ruling now. And I actually have much more elaborate submissions to talk you through the challenges of particular proposals. But I mean, unless your lordship thinks that actually I need to persuade you on that front, I propose the shortcut, and we could leave it there.
Well, my immediate reaction to what Mr. Conte said was that where emails are concerned, I just don't see an issue. There might, as you say, be the possibility of attachments that are there for one person and not for another, but that would then be a different document. But
yes, my lord, and also, I mean, it is also true that we're dealing with just pure copies of the same communication, in the sense that if I receive an email and I forward it to Miss Bell, that's a new document. That's not what we're talking about. We're genuinely talking about the two sides of the same communication.
But as I say, I don't think Mr. Shivji sees any problem in that, nor do I. But what it does seem to me is necessary to be done is to identify what other documents we're talking about, which can then be the subject of discussion, to see whether or not there is, quote, duplication in any real sense of the word, or whether there are different documents. So all I need do probably at this stage is simply to state those two principles for the parties to go away and work out what they need to do, unless you have a suggestion to the contrary, Mr. Conte.
No, that sounds like a very sensible way forward. That's a very helpful indication, and I'm grateful. And I think, in my view, the parties can deal with this in correspondence.
All right. Good. And we're due back again on the 3rd of September. Is that right?
We are indeed.
We are, my lord. That's right. It would be just helpful if your lordship agreed with my analysis of what a document is. It would just be helpful for your lordship to confirm that, because I think when it's very important that we're all speaking on the same basis. And if we understand that the example I gave of two documents, one was sitting with the first defendant and one sitting with the second defendant, on their own service basis a different document, and that will facilitate the discussion.
Well, it's self-evident that if that the location of a document is important. If it's exactly the same document, it makes no real sense to have two copies of it in the bundle for trial, as long as it's quite plain who are the recipients and who had it at what time, because that might be important. It might not be significant at all, but it might be of importance to show that someone had a particular document and was aware of it. And again, practicality is the issue here. If someone's made a note on a document, then self-evidently it becomes a different document. But you're well aware of that. I don't think there's any room for debate about it, really. So I think we can probably leave that point there on the basis that you'll come back to me on the 3rd of September if issues still exist in relation to this. But I, for one, would want to know what the other types of documents are. And, there are 45 supposedly as between the 4th and 5th defendants. I've no idea what the position is, so to speak, between claimants and defendant 4, but one would assume that just about everything was an email. But maybe I'm wrong. But,
I don't know. I appreciate the point, my lord.
September the 3rd, if there's still a dispute.
Yes. Yeah.
All right.
And also, I mean, my just for clarity, our suggestion on this front is that if what my learned friend is saying is the real problem is emails, and that's a bulk of the documents, then let's agree between us. We will agree a protocol in relation to emails to eliminate, and then they'll just need to give the rest, because there's no point spending lots of money trying to eliminate potential duplication in other areas where actually, as you say, there are very good reasons for their having to provide every copy. Anyway, there we go. That's that. So I think, my lord, the next thing is this. I keep on calling it pseudo anonymization. I can't get my head around the term.
I would suggest perhaps the way forward is for us all to refer to the protocol. That might be an easier way forward to save everybody mispronouncing the term.
Anyway, this is my learned friend has the floor on this, and he will take that forward.
Right. We'll refer to it as the pseudonym protocol. We can each.
I'm very grateful, my lord. I'm very grateful. So I think the starting point here is paragraph 37 of our skeleton. So the first claimant and the 5th defendant hold relevant documents containing sensitive material concerning the personal or financial matters of the 4th defendant and the 5th defendant's clients. Such information includes, among other things, client names, and it's important that they are, or many of them are, current client names. Those clients' contact details, which includes things such as their email addresses and their residential addresses and date of birth, and those clients' bank account numbers that are referred to as BP numbers. So in our submission, that information is plainly confidential, and it could potentially cause serious damage to the interests of the clients of the 4th defendant and the 5th defendant if it were released into the public domain. So that's a starting point. So the practical problem that the parties must seek to solve is this. What is the best way to protect this confidential information that derogates least from the open justice principle, but is, so far as is possible, consistent with the overriding objective? Now, we say there are various alternatives to the pseudonym protocol that can safely be ruled out, and I'll give 2 examples. On the one hand, it might be suggested that any hearing or part of a hearing could be held in private under Rule 35.4, Sub-Rule 3, as the facts clearly involve, and I quote, confidential information, including information relating to personal financial matters and publicity that would damage that confidentiality. But we say that involves a significant derogation from the open justice principle, and another method should be preferred if it is likely to be equally effective in protecting these clients' relevant rights. On the other hand, in paragraph 11.3 of my learned friend's skeleton, and you'll find that at page 4551 of the bundle, the claimants contend that the best way forward is to adopt what seems to be a 2-pronged approach. So in essence, the claimants propose that for disclosed documents, they should be left to be protected by the collateral undertaking in Rule 28.64. And for hearings, the parties should adopt this procedure, and I quote, Insofar as any party wishes to refer to a document containing any genuinely confidential information at a public hearing, the parties can liaise as to how best to protect that confidentiality by reference to the specific documents. We say this two-pronged proposal has several drawbacks. So insofar as the documents are concerned, the claimant's suggestion that the collateral use undertaking can provide sufficient protection simply does not work. As we point out in paragraph 36 of our skeleton, that undertaking falls away when a document has been read to or by the court. As such, as any hearing bundle will include the relevant documents, the undertaking will fall away when that hearing, which would include the trial, begins, and the relevant information, if not redacted, will be left unprotected. As regards the proposal in terms of what happens at the hearing, we say the proposal is likely to be ineffective. I personally have been involved in cases where counsel teams have sought to implement a gentleman's agreement of not referring to a particular item or several items of confidential information during a hearing. On many occasions, someone has, totally innocently and inadvertently, slipped up and referred to the relevant information. On one occasion last month, regrettably, it was even the judge. The problem is that once a piece of confidential information is mentioned at a public hearing, the toothpaste is out of the tube, as it were, and you can't put it back in. In addition, the claimant suggests that the parties should liaise about how best to protect any relevant information, and I quote, by reference to the specific document. But we find that suggestion curious. In principle, what matters is the nature of the confidential information in play, not the document in which the information would appear. So, for example, assume an email contains a client's name and corresponding BP number, and that a report does the same. Is the approach to confidentiality to be different? I would think not, at least in principle. The suggestion also raises practical issues in circumstances such as these, where counsel may be dealing with a large body of documents, perhaps because here we're dealing with hundreds of different clients. How will counsel and the court remember the different ad hoc singular agreements made in respect of a vast number of different documents? Lastly, the claimant's suggestion is that the parties must debate an individual scheme that is to apply document by document. We say that's a recipe for incurring unnecessary cost. So given this, the defendants have proposed what we say is a pragmatic solution that will allow all of the hearings to be held in public and will very likely ensure that no inadvertent disclosures are made, but will restrict any confidential information from entering the public domain. So our solution, and to be clear, it's only to apply to the first claimant and the fifth defendant, the pseudonym protocol is at 4602 of the bundle.
It's attached to your draft order.
It is indeed. So Appendix 1.
Yeah.
If you could please turn that up, my lord.
Yeah.
So the protocol applies, as I said, to each of the, well, it will apply to each of the clients contained in the client logs that the first claimant and the fifth defendant exchanged on the 17th of June 2024. And then we set out.
Can you remind me of the numbers?
Of that client log?
Yeah, of each.
Could you bear with me one moment while I take instructions on that point?
Broadly, I've forgotten, but
400 in total, I'm told, my lord.
Right.
So we then set out a 5-step pseudonym protocol. First, the legal representatives for each party, i.e. the legal team, shall jointly assign a unique pseudonym to each client who may be identified from any disclosable document. 2, the parties shall use that pseudonym throughout the disclosure process and the proceedings in order to refer to the client and any confidential personal or financial information relating to that client, such as BP number, email address, residential address, or date of birth. And then we give an example. If a particular client is given the pseudonym client 1, the parties will simply refer to client 1's BP number, client 1's address, so on. Third, each legal team shall maintain a confidential list of client BP numbers, their corresponding information such as client names and pseudonyms. The legal team shall not disclose this list to any person outside of a designated confidentiality ring or the court, except as required by law or the order of the court. 4, each legal team will mark any document that contains a pseudonym to indicate that it has been pseudonymized in accordance with the protocol. And lastly, each legal team shall redact any other confidential personal or financial information that may identify the client, whether directly or indirectly, and explain that redaction by referring to the pseudonym. For example, if client one's BP number is redacted, a note will be used to identify the redacted information is client one's BP number. Now, I wish to make 5 observations about that protocol, if I may. First, we say the scope of the protocol goes no further than the minimum necessary to protect the relevant client and his or her confidential personal or financial information, in particular in light of the possibility and the risk of jigsaw identification.
Can I ask this question, though? Again, looking at the reality of what the trial is likely to involve, self-evidently, there will be reference to the client in question, 400 it may be.
I'm told, sorry, my lord, it's actually 560. I've been corrected.
That sounds right. That rings a bell, that number. Yeah.
Apologies.
Right. No, that's okay. And self-evidently, there would be reference to the individuals by name, absent some process of the kind you suggest. But why would there be any need to refer to bank accounts, residential addresses, or anything beyond the name? I'm just trying to think of the practicalities. What's really going to happen at trial? Again,
we had been pursuing. We had been proceeding on the basis there would be a need to refer to them, but if a regime was put in place where they wouldn't be referred to at all because they're not relevant, but my understanding is that wasn't the claimant's position.
Well, why would they be relevant on the face of it? I mean, you know, we know what the essence of this case is about, namely that the business and the clients and the relationship managers have all gone, been stolen, effectively, that's what's said, or at least by agreement between the directors on both sides of the joint venture have split the business between them to the detriment of the company. But I can't quite see why we're looking at the recruitment processes, we're looking at the way in which these clients have been taken on board and so on and so forth. So I understand fully client names, but I can't for the moment see why anything else is going to matter, really.
My understanding is that there may be documents put up on a screen and they will refer to the BP numbers, or they might refer to the other information during the trial.
Right. Okay. Yeah, sorry, you carry on.
And also, I'm told that some of the clients' names are BP numbers. So there's a crossover.
I'm not understanding that point. How can the BP number is the bank account number, as I understand it?
And Swiss numbered accounts, my understanding is it will include the client name.
I don't think that takes it any further, but you can come back on that if I've misunderstood. Yeah. Anyway, your first point goes no further than necessary. Your second point?
There's great utility in grasping the nettle now and deciding the point now rather than doing it at some point down the line, just because there will be multiple hearings before the trial. So understanding what the position now will allow, counsel will have certainty about knowing how to refer to any of this information in oral submissions, and the lawyers will have, and the court will have the opportunity to familiarise themselves with the regime before trial. And it'll also be more effective when it comes to the preparation of witness statements. It'll be easy to draft, and with the protocol sitting next to the drafter, who can then just insert the relevant or have the relevant process in mind while they're drafting witness statements or reviewing witness statements. The third point is that we say the pseudonym protocol will not cause the claimants any prejudice. So specifically, as we point out in paragraph 42 of our skeleton, the protocol won't restrict the claimant's access to any relevant information, as the claimants already have access to much of the relevant confidential information that would fall within the protocol. So in any event, the claimant's legal team will know the identity of each client subject to the protocol. However, in paragraph 11.1 of the claimant skeleton, and that's at 4550 of the bundle, the claimants say the protocol is disproportionate because, and I quote, the scope of the redaction is likely to be excessive, time-consuming and costly. And here, there's essentially 3 points. In a battle between a third party's right to confidentiality and a litigant's cost of imposing measures to protect those rights, we say, in principle, the former must win. Second, in any event, cost considerations militate in favour of addressing the issue today, as opposed to addressing it at some later point in time, as both parties have their e-disclosure providers on hand and they can apply any restrictions that need to be applied quite quickly. And there are, of course, technologies that the parties can explore in correspondence to assist with any time and cost implications of the regime. So my fourth point is that in paragraph 11.4 of the claimant skeleton, they say that the purpose of the proposed confidentiality club is not understood on the basis that regulated solicitors are conducting all parties disclosure exercises and the current liquidator is an officer of the court. In response to that, we note that providing that parties enter into a confidentiality club is an orthodox step in cases involving confidential information, especially in cases such as IP cases. And such an agreement is essential because in the usual way, the parties will need to extend the confidentiality arrangements to expert witnesses. Finally, in paragraph 11.2 of the claimant's skeleton, and that's at page 4550 of the bundle, they state as follows: it is striking that the identity of clients has already entered into the public domain through various documents being deployed in these proceedings at hearings in public. The defendants have expressed no concern about that today. Well, there are 2 points here. The first is that the protocol focuses primarily on clients' confidential personal and financial information, and in some instances that relates to live client accounts. To date, the parties have included very few documents concerning clients' personal information in court bundles. Rather, most client-related documents have simply been exchanged between the parties as a result of the court's orders. But the second and more important point is the defendants have, in fact, taken issue where the claimants have failed to redact client names and associated BP numbers. For example, and although I'm not asking your lordship to turn it up, in a letter dated 5 April 2024, Jones Day wrote to HFW noting that the claimants had failed to redact client names and associated BP numbers in documents that the claimants proposed to include in the upcoming hearing bundle for the defendant's strikeout application. And following this, 4 days later on the 9th of April 2024, HFW replied, stating that they were content to make all of the requested redactions save for one. Unless you have any questions, my lord, those are my submissions.
I mean, I take it that if this redaction is done to the disclosed document, I mean, it's going to be a pretty extensive exercise, isn't it?
Again, I couldn't give you the numbers. I don't have the numbers offhand, but my submission would be it is whatever it needs to be to protect the information.
Yes.
I mean, here we're dealing with what is a very important right. It's the right to protect confidential or personal sensitive information. I mean, although the submission is a private hearing is too much of a derogation, it is one of the bases upon which one can apply for a private hearing. And usually they are cases where the information is given quite a heavy weighting by the law in order to derogate from the open justice principle.
Let's just focus for a moment on the identification of the client, because it seems to me at first blush, you know, that it's inevitable that in arguing about whether clients have been suborned, if that's the correct expression, the identity of the clients will be very much a matter for the court. As I've already suggested, I can't quite see why anything much beyond that would be necessary. And why is it so important that the identity of the client is in itself confidential?
Again, the idea is it's the identity of the client in connection with other factors, but it's also because we are dealing with a Swiss bank and we are dealing with a jurisdiction in which discretion and confidentiality is primed. And it is one where, as compared to other jurisdictions, the value placed on that right is, we would say, greater in Switzerland than it is elsewhere. And it may affect the person quite deeply and quite gravely if their name was mentioned in connection with these proceedings.
Whether for tax or other reasons. Yeah.
I don't venture to opine on the reasons, but I do think that.
Well, absolutely, it's not a matter. But yeah, all right. Well, I understand the point. And what do you say about the fact that disclosure's already been made of many, well, some at least, presumably, of these clients' identities in court?
Again, my understanding is in the few instances where this has happened, Jones Day were very quick, and there was only one in relation to the particulars, only one name that was mentioned in the consolidated particulars of claim. But beyond that, in the two other instances that I've been made aware of, Jones Day were very, very quick to make sure that the bundle was correctly redacted, wrote to HFW, and the problem was rectified. But even if it has been an issue, which I don't understand has been, but even if, in principle, we say that can't be a good reason for then saying, well, all client names should be disclosed. I mean, again, in the hearing that I was saying earlier, unfortunately, my learned leader mentioned what he shouldn't have twice, and the judge mentioned it, and we just tried to put the toothpaste back in the tube, which was unsatisfactory, but we did the best we could. But it didn't mean going forward the parties didn't agree to a suitable confidentiality regime.
As matters stand, court hearings are open to the public to listen to in the DIFC. They can be, you can get in on YouTube and follow it on a daily basis. So far as transcripts are concerned, I think I'm in a position to make orders that transcripts are not to be made available to non-parties, save with the permission of the court, and likewise documents. I'm just trying to think of the range of options that might be available in this context. Have you looked at those other possibilities?
Not in detail, but my understanding was that public hearings that are it will be a public hearing and it will be in person at the trial. So someone could, and as they did in my other matter, there were people sitting in the back of the courtroom who sat in, and because it was public, they obviously heard the words mentioned that shouldn't have been, and so that does pose in itself a problem. The transcript, I take your point, and that was what we did in my other matter, in the sense that there was an order made about ensuring that the transcript was amended and not provided to anyone in unredacted form. I guess it's a question about how to draw the right balance, but there's also the issue about the production or the usual routine of this court of posting hearings on YouTube. So they are publicly available, and again. If counsel are to refer to the names freely, anyone sitting down with some time on a Friday night with nothing else to do could just sit there and go through the trial. Or indeed, it could be a banking competitor. It could be someone interested in the information. I assume that the trial will get some publicity at the time. So it probably will be. There will be people who will be interested in the contents and the outcome. And I guess my submission is, we appreciate this is a difficult practical problem. We are just trying to find the best way to solve it. And this is what we've been able to come up with based on where we are today.
Yeah, well, that's why I was looking at the other range of possibilities.
Yes.
I can't quite see that the confidentiality ring is required. You know, the real issue here is not information available to the lawyers on either side.
We just have to find a way in relation to expert witnesses that they would have to be subject to some type of restriction. So the usual way I've seen this done is there's a confidentiality ring, and then the expert witnesses sign an undertaking in relation to whatever matters are contained in the confidentiality ring. That was the thinking behind the ring.
Yeah, well, the expert witnesses can easily give undertakings to the court, but I say there's no real purpose in a confidentiality ring that relates to specific lawyers, for example. The real problem from your perspective is that the information gets out into the public.
Yes, yes. I mean, again, my
competitors or whatever.
Yes, I mean, the point about the confidentiality ring, and to be very clear, I'm not incredibly wed to it. I was just explaining the thinking again, is how it's normally done, and just trying to catch anything that may fall through the net, given that I'm speaking from experience about how I've normally done these things in other cases.
Yeah. Well, I mean, we're all familiar with how that's done. Have you thought about how this material would actually come out in court? I mean, that's what I keep trying to work out for myself. That there'll be an argument about whether particular individuals have or have not been, quote, poached, unquote.
Yes. And in connection with that argument, you could see how it might be relevant to talk about the account number connected to the client.
Maybe.
Especially when you're discussing assets under management.
Yes. Well, that doesn't seem to me to follow necessarily, but I take the point. All right. Is there anything more you want to say at this stage?
No, my lord.
No, thank you very much. All right, Mr. Shivji.
So, my lord, we say this is not an issue for now. That's the short answer. And I'm not saying that we can't revisit issues of confidentiality later, but this is not the time for it. I will develop that submission in a moment. But if my learned friend's concern is client names and BP numbers, the confidentiality in that material has already been lost. And I'm looking, for example, at the November hearing, 1st of November 2024. There were extensive lists in the bundle there of hundreds and hundreds of clients alongside their BP numbers. And no objection was taken to any of that material going in the bundle. It went before your lordship then. So I'll come back to that point.
That bundle is not available to the world.
It's not, but if documents going into a bundle for a hearing in public, which has been relied on by the judge, results in a loss of confidentiality, then that confidence is lost. And if it doesn't, then that's an answer to my learned friend's concern, in that you could just put documents about clients into the bundle and we can manage that at the hearing. But if I may, my lord, perhaps I could just develop my submissions on this and then perhaps assist.
Before you do, let's just explore that point of principle. As I read the rule, the RDC rule, that talks about documents which are referred to in open court. If you look at the grammar of it and the placement of the commas, it's documents which are read to or by the judge in the court. Now, my recollection is that there's English law authority to the effect that if it's in the bundle that is read by the judge beforehand, it's exactly the same as if it had been spoken openly in court. And I guess that's the principle that I would have to apply here. So once it's in the bundle, it is then, and read by the judge, it is then subject to court by the rule, so to speak.
Yes, and that's what we think has happened. Now, I appreciate I'm being cautious, because what I don't want it being said against me that I've somehow revealed the contents of the documents and apricot. So I'm not going to talk about the content of them, but
No.
that is actually what we understand happened in the November hearing. And there were various lists in there that came before your lordship for different reasons as part of different points, and none of that was redacted.
I recall seeing lists of names.
Yes. That is also our understanding, that your lordship has seen lists of names, and alongside, and I'm looking at documents now which have not just lists of names but also lists of their BP numbers alongside them. So I mean I make that point actually not so much to press the point the genie is out of the bottle, but more to say this is a slightly unreal engineered concern late in the day. The defendants had no problem. You can see from the security of the costs application the size of the defendant's team. I think there are over 40 fee earners who've acted on this matter. The idea that they somehow missed all of this information going to the bundle, didn't realise, and that it was super secret and couldn't be disclosed is unreal. I mean, these are, my learned friend was quite careful to draw a distinction between current client information and historic client information. But the vast majority of what's going to be relevant to this case is historic client information from more than 10 years ago. And I understand that in some quantum areas there may be questions about current clients, but I don't think the focus of this case is going, as we understand it, is going to really relate to current clients. It's all about these historic clients, and as you say, whether they were moved to a different institution. So that material has all been in play for some time. Your lordship has seen it. We think an analysis on the principle your lordship has identified that it has entered the public domain. But that really just gives you an insight into these alleged questions of confidentiality. And I was a little bit perplexed by the regime that my learned friend puts forward, because his regime only applies to the first claimant and the fifth defendant. Now, the fifth defendant is a DIFC regulated entity. It is only subject to the DIFC data protection law. And, much like the English law, there is no data protection breach where the court has ordered information to be provided. And all of this information is going to be provided pursuant to your lordship's disclosure order. So there's no DIFC law that's being breached or confidence that's being violated as a result of this information being given. And for the fourth defendant, my learned friend doesn't seek any anonymization protocol. So this is only a regime for D5 and C1. Anyway, perhaps I could just develop this, my lord. I've got 5 points that I wanted to make. The first is, and this is really, I think, what your lordship was getting at, that this court has highly developed mechanisms for maintaining the confidentiality of information which is genuinely confidential. That's my first point. And there are various routes. There are at least 4 routes we can think of for that. One, there's a collateral use restriction. 2, it's possible to have confidentiality restrictions so that the confidentiality material in the bundle is not automatically lost. 3, counsel can navigate confidential information. My learned friend talked about counsel making slip-ups, but when I started my career, I was doing applications to restrain the advertisement of the winding up of companies. And in those applications, you cannot mention the company in open court. Otherwise, you undermine the entire purpose of the application. So it was always done in public. It was always done with an open bundle, but you would always, as the advocate, have to navigate through that and not put your foot in it. And we managed, because we'd been taught that's what we had to do. So counsel are capable of navigating it in the way that I'm trying to navigate it at this hearing. And then in the worst case scenario, when it really is impossible to navigate, the court can order that the hearing is in private. So those are some of the many mechanisms that your lordship has. And those are mechanisms all for in due course. They're not for now, they're for when we have public hearings. So that was my first point. My second point is that my learned friend says that all this information is confidential, and that there should be a regime to redact it right the way across disclosure. We've never come across a regime across all of the banking litigators on our side where this has been introduced in a case. And we say that having done the Icelandic collapse, Lehman, many of the very, very substantial banking disputes over the last 15 years. So it's an idea that we've never come across. the information has many characteristics. And when my learned friend talks about email addresses and residential addresses, I mean, that information may not be confidential for these clients. But in any event, as your lordship says, I struggle at the moment to see how during the course of trial, we're going to be spending time looking at people's residential addresses. So we say it's just all a sort of essentially a overreaction to what is material that is already out there in the public domain. And you quizzed my learned friend on what this exercise would cost, and he had no answer to give you on that. I mean, the note that I took when I was preparing for this is essentially what is the impact assessment of this proposed approach? And if the court's weighing up the different options available, the court would need to know what the impact is. And we would say what my learned friend envisages is a re-review both of the claimant side and the fifth defendant side of all the documents they're going to give, and on a document by document basis, hunting for this sort of information. It's not generic information, it's client specific. So you can't search for it with a search function, you've got to look for it across all of these documents. And that would cost a large amount of money and take a huge amount of time. And we just say that given the scale of the impact, this surely has got to be an easier solution. So that was my second point. The third point is it leads to very odd results, because on the claimant side, we would have all the unredacted documents as well as the redacted ones. So we're just, I mean, logically, my learned friend's not seeking an order that we can only work from the redacted ones. We'd just work from the ones that we've already got, including ones that my clients have already sent us, which has got all the client information. So it's a very odd world where we have to redact our documents in relation to their clients, and they get the redacted documents. We can continue working from the unredacted documents, but in circumstances where they know all the identity of the clients anyway, because they have a set of their own documents relating to these clients. So I don't understand, in terms of redacted documents in disclosure, who we're trying to protect against who. But it seems to us an enormous amount of money would be invested in creating these rival sets of documents. This brings on to the fourth point, which is that the way that's expressed in Jones Day's letter, I'd like you to have a look at that. That's 4456, please.
Sorry, bear with me.
Of course.
Yeah.
So at the end of this is a Jones Day letter, paragraph 39.39a at the bottom. They say the purpose of the protocol is not to protect any privacy of client names as between the claimants and defendants, as to such an extent, as to a large extent, as such a measure to a large extent already known between the parties and or on the court records. Now that's a very important point, because it's already on your, they're right to say that it's already on your records as a result of material I've identified. And then they go on the next page to say the purpose of the protocol is to protect other forms of information, such as BP numbers and email address, from being released into the public domain, since these proceedings are and will be held in public. Now, there's no suggestion there that the client name is the issue. The references to other forms of personal information, and they talk about BP numbers and email addresses. Now, as I said, actually, we think the genie is already out of the bottle on the BP numbers, and the BP numbers were even exhibited to our particular claim in this matter. And we think on the email addresses, we just think this is a sort of unreal concern. I mean, most of us, our email addresses are papered all over the internet, so there's no real confidentiality. But also, I just can't imagine in this trial that I'm going to be reading out email addresses to your lordship at trial. And if your lordship says I'm not allowed to do that, I will obviously have no problem with that. I don't think it's going to affect my conduct of trial at all, if that's what your lordship says. So looking at the very narrow type of information that they want to protect, we say that this is a real sledgehammer to crack a nut. Now, I don't want to be accused of overstepping by putting documents out there in public, but I've given you the point that from the November hearing, there are very lengthy client lists in there. I'm not going to give your lordship the page numbers. I think that's the way I navigate this particular problem. But actually, I frankly found them by just scrolling through the bundle pretty quickly. And some of those pages run over many, sorry, some of those lists run over many pages. And so you suddenly hit a long list of client names and client BP numbers and also assets under management as well. And on top of that, our pleadings refer to a client by name. And actually, I saw the defendant's skeleton for the September hearing at 1652. If you could turn that up, please.
Yeah.
And I won't read out the client name, but they're at 63.3. This is the defendant's skeleton, and they refer to a client name there without any expression of concern about that name. And again, without mentioning the name, but at the September hearing, I took you by way of example to a set of emails about a particular client that's not this client, it's a different client and their company. And again, that was something actually that your lordship looked at. And again, there were no concerns expressed by defendants there about the identity of that client being revealed. And that was a different client to this one. And your lordship has previously ordered that the parties, the first claimant and the fifth defendant, exchange lists of clients. And although those lists of clients didn't go on the court file, they have gone in the bundle, and they were in the bundle for the November hearing. And again, they were listed of names of clients alongside their BP numbers. So we say there doesn't actually seem to be a concern on the defendant's side about the identity of clients being disclosed. And it has been disclosed in the past. And we're talking about 10 years ago. So it's a bit unreal that anyone's very sensitive about this. And then the fifth point is really full circle, which is there are plenty of mechanisms available to the court to deal with genuinely confidential information not being released to the public through a hearing. And I'm completely happy as a matter of principle for that topic to be engaged with by the parties ahead of trial. And when we look at actually what the parties have asked to go in the bundle, if there are particular concerns about particular documents, we will look at that. And I have no reason to think that we won't be able to navigate that. I suspect at trial the easiest way for your lordship to deal with the case will be to deal with it by client name. That's how this case has gone so far. And I can't see an objection to that. But beyond that, I'm not really convinced that we'll need to descend into any other personal information from clients. So, my lord, those are my submissions on why this proposal should be rejected.
Yes, Mr. Conte.
Thank you very much, and thank you to my learned friend for his submissions. I mean, on this point, I've taken note of what he's had to say and what you've had to say, my lord. And I think the way forward might be for the defendants to go away, to consider what's been said, and perhaps for the parties to liaise in correspondence and to see if there might be a way through. And if there's still an issue, we can bring it back before you at the next CMC. But I think this is one that, again, with some of the other topics, it may be helpful if there's some correspondence to see if we can come up with a proposal that's mutually acceptable.
Yeah, well, I think that's right. I mean, Mr. Conte, my initial view is that what is suggested in the context of disclosure is both novel from my perspective and also going to be incredibly time-consuming and expensive, involving, as it appears, a complete review of the documents to see how these points arise. whereas there ought to be other methods to preserve what is truly important with client numbers or whatever it may take in use at the trial itself. For the moment, I can't see any. You may want to think about how witness evidence and cross-examination and so on is going to take place, and indeed, obviously, submissions. But in the context of poaching of clients historically, what matters for liability purposes is the identity of the people concerned rather than anything else. And I can't see the need for much other information to be referred to at all. In the context
that's very helpful, my lord. Thank you.
In the context of quantum, I can see problems could arise because one would then be into current information as opposed to merely historic information, and what I'm not quite sure how quantum is worked out. But in relation to valuation of business lost and so on and so forth, I can see that the ongoing relationships and the ongoing business has an impact or may have an impact on any valuation of the rights that have been allegedly lost. So go away and have a think about it. I think there ought to be a way through this with tailored orders made at the time or before the trial in relation to the way things are going to be referred to, and possibly restrictions on transcripts and documents being available to non-parties. That's my initial view. Confidentiality ring I don't think really applies, other than making sure that experts who are not parties as such, or individuals who give evidence, are bound by undertakings that are similar to the collateral undertakings that the parties give in any event. So I'm not at all unsympathetic, but I think this is probably a bit of a sledgehammer to crack a nut on current information, at least.
I'm very grateful in particular for your indications, my lord. They will be very helpful. We'll go away, we'll take on board what you've said, and we'll address, or Jones Day will address the matter in correspondence with HFW, and if need be, we'll bring it back before you, but hopefully with some more developed thinking and perhaps even with an agreed way forward. But thank you.
All right. Okay. What remains?
I think we have now hit keywords, but it might be a good time to have a break because I appreciate we have been going for 2 hours and 10 minutes.
Are you tired?
No. I was just, do we have transcribers who might need, it's the middle of the day. I don't know where you are at the moment, my lord, but we're in England. I'd be worried if I was tired at 1:45. But it's totally up. I just thought the transcribers might want 5 minutes, 10 minutes, whatever they can afford.
Wait till you get old, Mr. Conte, but yes, let's take 10 minutes now.
My lord, my boyish good looks deceive you. I'm actually not that young, but there we are.
Well, you are by my standards.
I'm grateful. Thank you very much.
Thank you, my lord. So I think we're on to the final topic, which is keyword searches. As we understood the position, the disputes related to some discrete categories of my learned friend's disclosure. We hadn't actually seen any opposition from him at all on what we were proposing on doing on our keywords. And if my learned friend has some opposition, I'll be hearing that for the first time, but I'll hear from that in due course. So starting, if I may, with the defendant's documents. I mean, what we're talking about here are very narrow categories of documents where we say, based on the information that we've got to date, that we think that the defendants need to go a bit further. If I start by going to 4459, please, of the bundle.
Yeah.
And this is, the category is about the fourth defendant's hypersuite software. And I will read for you a reference to their evidence about what this software does. and I'll give you the reference, but you don't need to turn up for reasons of speed. So in Mr. Tourette's witness statement, paragraph 22, he explained that the fourth defendant uses Hypersuite to store KYC documentation and documents pertaining to client output, such as transaction advices and account statements. There is also where contractual documents with clients are stored. He says Hypersuite is in essence a database of PDF documents organized by individual client. The specific documents held for each client vary depending on client practices and selection of services. So that's what Hypersuite does. If then looking at the page I've just turned you to of 4459, the searches that we have proposed generate 823 documents for review. Now, the search terms that we've identified, we think are not similar to any other search terms. So these are client communications, and what we want to try and capture is communications where it's been said to the clients, look, because of a merger or a divorce between these companies, or because of the creation of a new company or a new entity, you need to come to the fifth defendant. So that's the sort of logic behind the keywords. And
I had a note. I had a note, Mr. Shivji, that 498 documents had been hit on the Hypersuite file. Am I wrong?
It says we'll add the results of this, but once you dedupe and stuff, what I meant.
Which paragraph?
51, so right above that. So that once you found them.
So your lordship's absolutely right. I'm grateful to my learned friend Mr. Sharafi for guiding me on this. If your lordship is entirely on the ball. 51 explains that once you've deduped, etc., it actually brings it down to 498. So I'm sorry about that, but you're right. You've got to the conclusion. It's 500 documents. We've just saved them a review of 50,000 documents. This is the speed of a reviewer is generally 500 documents a day. This is one person, one day. And we say that the categories they're clearly relevant. It's not that they're captured by something else. They are capturing something that's potentially relevant to this case, and we just don't think it's a big job. Now, my lord, it might be most sensible actually for us just to deal with this category by category. So it may be that you need to hear my learned friend's objections on Hypersuite before we next move to the next one.
Yes. Well, is that satisfactory, Miss Bell? Are you happy with that?
Yes, my lord, I'm happy to do it in that manner. I think logically, I'm happy to deal with our issues with the claimants' keywords for their repositories first, and then I can move on to Hypersuite, because the points we do have to make on the claimants' keywords, I do hope are uncontroversial and can be resolved in correspondence. So if I may, I'll make our points on those first and then move on to the Hypersuite repository in the fourth defendant. So my lord, the reason why we hadn't dealt with it in our skeleton argument is that the claimant's propositions for search terms for their hard copy documents and the former liquidator's working papers came to us on the 4th of July. And there has been some back and forth between the parties in correspondence on those repositories. And the defendant's position is we don't have full transparency on a few discrete issues, and that's what we're asking the claimants to provide. And I do hope it's an uncontroversial request. So turning first to the hard copy documents, the claimants are proposing to search those documents by reference to date ranges and exclusionary terms. So they're not proposing to use keywords to search that repository. The defendants, in principle, agree to that proposed approach. However, they do want to make it clear that the agreement is for phone bills and expense claims, and it is also agreed on the basis that World Check and KYC forms are not attached to other forms of documents such as call logs. Now, my lord, the reason for the defendant's position on this is as follows. Because the claimants are only applying exclusionary terms and not keywords to the repository, any document that contains the exclusionary term will be removed from the review population. The scanning of hard copy documents can lead to documents being oddly bundled together rather than being individually separated. Now, the claimants have told us in correspondence that the vast majority of their documents have been scanned individually. And what the defendants are asking for is clarification that it's not going to arise that exclusionary terms are going to be applied to a large bundle of documents that have been scanned, not individually, such that those documents will be excluded. And so that's why the defendants have caveated their agreement in that manner. And my lord, if the claimants can write to Jones Day and clarify that that is not going to arise and that they verify that KYC forms are not attached to other forms of documents such as call logs, then we are satisfied with their approach. But we do need some engagement and clear communication on that issue. On the former liquidators' working documents, my lord, the claimant's proposals are not to apply any keywords and effectively to search 6,311 documents. My lord, we've heard what you've said on deduplication of the defendant's documents. The defendants are content in principle with the claimant's proposed search of this repository in the manner proposed, on the basis that any deduplication applied to the repository is done to the same standard as the defendant's deduplication is being done, and subject to the following final caveat, which is the defendants have asked questions about how the relevant review population has been reached. We say that because we've been informed that out of 136,888 documents, only 6,311 need to be reviewed. So some 130,000 documents have been excluded. And what the defendants are asking from the claimants, and again, I do hope this is uncontroversial, is for a full explanation of how that number has been reduced and how the folders that have been excluded have been identified. And we say this for the following reasons. Either it's extremely impressive in terms of efficiency, and we want to know how they did it, or it does raise some concerns, and we need to know how this process was done because it is such a vast reduction. And the claimants will obviously be aware that of all the repositories, this is one in which the defendants might have a particular interest in order to understand how the liquidator formed their views on the defendants, and in the defendant's case, the flawed views that they reached about the winding up of BSA. The defendants would expect, in terms of the dealing with this repository, that at least a sample of documents and folders would have been reviewed to ensure that they don't contain relevant documents. So all we're asking, in order to give it an informed view on this particular issue, is that that information is provided in full to the defendant so that they can understand how this repository has been searched.
Right. I've noted down all that you've said, but you haven't yet moved on to deal with what Mr. Shipji dealt with.
Yes, I'll move on to the Hypersuite repository. Apologies, my lord, there was just some technological difficulties on our side. My lord, the first point I have to make is a point that applies across the board to the defendants' repositories. and the additional keywords that have been requested in relation to all of those repositories. The defendants are inviting the court to reject the claimant's proposals to add additional keywords to those repositories at this stage, and that the court should not endorse or condone late additions when a first level review has already been conducted. Now, my lord, before making my submissions on that overarching point, what I do want to be crystal clear to the court is the defendants are not simply refusing to do searches using these keywords. The defendants are already doing hundreds, if not thousands, of searches, which include each of the claimant's proposed additional keywords. They're being applied against custodial repositories. What the defendants are refusing to do and ask the court to endorse is to search for such words being sprung upon them at this late stage in this process, being applied to non-custodial repositories where they're unlikely to produce relevant material and where the cost and time of doing so now is entirely disproportionate. The defendants say that the documents that the claimants are likely to be interested in, to the extent they exist, will already be captured by the vast number of searches that have already been conducted. And to implement these additional words after a first level review has been conducted of the repositories in issue is just too expensive, too time consuming, and it comes too little too late. Turning then, my lord, to the principled objection that the defendants have, I don't seek to dredge up past backs and forths between the parties, but it is important for the court to understand this aspect of why the defendants have taken the stance they have. There is a degree of frustration with the attitude that the claimants have taken to this process to date. The defendants have incurred over $1 million US dollars in this process to date, and they have had to manage the process very carefully to ensure that it's completed on time and with appropriate diligence. Jones Day wrote to the claimants more than 17 weeks ago, on the 14th of March, setting out the proposals for keywords in relation to the repositories before the court today. They requested a response to their proposals within 14 days. Now, on my submission, that is ample time to consider proposals that have been made and provide views. The claimants proceeded to ignore the defendant's request for the proposals for a period of 16 weeks. Now, the claimants, in their skeleton argument, appear to attempt to justify this and the subsequent stonewalling of the defendants on this issue on the basis that the claimants were required to renegotiate their agreements with their funders and their insurer to account for the associated increased costs on due to the adjournment of the trial at the last CMC. Now, my lord, there are two responses that the defendants have to this. First, the court should not buy this narrative because during that period and during the period the defendants were expecting an answer to their proposals, the claimants were able to progress their own disclosure and incur the costs of the same during this 16-week period. This can be seen by having a rudimentary look at their disclosure report on page 2076. At paragraph 6 of that document, we can see that HFW in this period provided the claimant's list of keywords and date ranges to be applied to the first claimant's custodial data on relativity with Ancora. In the same paragraph, Ancora completed their review of the terms by the 26th of March 2025. HFW shared the final list with the defendants on the 28th of March, the date by which the defendants requested a response to their proposals on their repositories. Paragraph 7, Ancora decrypted the documents on the 27th of March. And the following paragraphs also indicate that the claimants were engaging in their own disclosure process on the 31st of March and that their custodial data was ready for review on the 2nd of May. So the defendant's objection is, why couldn't the claimants have responded to the defendant's proposals during this period? The defendants engaged with the claimants during this period, as referred to at paragraph 10 of this document on page 2077, where they provided the defendant's feedback on the claimant's proposals in relation to their disclosure. So the claimants, we say, were not disabled from progressing disclosure issues as suggested due to funding issues. And secondly, my lord, the submission on this point is, even if the claimant's funding difficulties did impact their ability to progress their own disclosure exercise, the defendants shouldn't be held up at the claimant's behest, nor should they be expected to wait to finalise their keywords, jeopardising their ability to meet a court-ordered deadline until the claimants got their house in order. Now, on the 11th of April, HFW wrote to Jones Day to seek a postponement of the CMC that was then listed for the 25th of April, on the basis that the claimant's disclosure review process wasn't as well progressed as they'd anticipated. And on the specific issue of the defendant's keyword proposals, HFW said, the claimants cannot come to a meaningful position on the suggestions put forward in your 14th of March letter until the CAL review has been further progressed. We are not in a position to forward our suggestions as of yet. So at the relevant time, the claimants were not saying, we can't respond to you because we don't have funding. Rather, they were saying, we want to get further ahead of our disclosure exercise before responding. Now, my lord, our objection is that is not playing by the rules. Why should the claimants be permitted to progress their disclosure exercise before engaging with the defendants on their proposals to progress the defendant's disclosure? The defendants were expected to engage with the claimants' proposals well before undertaking the defendant's CAL review, so why should the claimants not be held to the same standard? Now, Jones Day then responded on the 14th of April, and their response is worth looking at, my lord, because it does outline the practical difficulties that the defendants are going to face if the claimants' requests are granted. And that's on page 4355 of the bundle. And it's paragraph 16 that discusses the defendant's proposals for keywords for the repositories and issues. So at 16.1, they say the keywords for many of the defendant's repositories are yet to be finalised. And from subparagraph A onwards, Jones Day sets out the consequences that the defendants would face if the claimants failed to engage on the issue of keywords and sought to add further keywords down the line. So they've said it will likely lead to additional documents being added to the review population after the defendant's third-party review provider has been asked to stand down. They will then have to restart the process. A first-level review team would have to be remobilised and retrained. That process takes at least 2 weeks. At B, if the remobilisation and training of a first-level review team was required, that would increase the defendant's costs of the disclosure exercise, which was troubling the defendants and remains troubling because, in our view, the security that's been provided by the claimants is inadequate. C, adding additional documents to the review population has the potential to destabilise the defendant's CAL algorithm. And that will then possibly add even more documents to the review population. And that the rescheduling is likely to impact the timing of the defendant's second-level review progress, and so on and so forth, my lord. There's a domino effect that occurs. So in my submission, the claimants were warned of what was going to happen on the 14th of April, and they still chose to ignore the defendants. And these points are still pertinent today, as they were then. Jones Day wrote to HFW a further time on the 7th of May to inform HFW that the defendant's first-level review team has substantially been stood down, that a skeletal team remained, and that was expected to complete its work that week. And they explained to HFW that in those circumstances, and I quote them, there is a vanishingly small window for the defendants to efficiently review documents resulting from any additional or amended search terms. So my Lord, Jones Day offered the claimants a further opportunity to make any additional proposals for keywords by the 12th of May, failing which the defendants would seek an order from the court approving them, which we are now doing. So my Lord, the claimants were given a further final opportunity to provide their additional keywords, after which they were told the defendants would stand down the first level review team. Now, my Lord, I note a point that my learned friend made in his earlier submissions, which is that the parties both have processes that they need to embark upon. They have embarked upon them, and disclosure will happen pursuant to that process. The first substantive engagement the defendants had on the defendants' keyword proposals for the repositories before the court came on the 4th of July, so less than 2 weeks ago. And they've requested the addition of more than 40 additional keywords or search parameters to be applied to 3 of the defendants' repositories. And not only that, my Lord, they didn't even bother explaining why there'd been a delay or why the keywords were being requested in that correspondence. The first time the defendants have received anything resembling a justification for these additions was in the claimant's skeleton for this hearing. So, my Lord, as a matter of principle, and this applies to all of the repositories, including the Hypersuite, the claimant's lack of engagement was unacceptable and should not be condoned by this court. Parties are expected to cooperate on the issue of keywords, and it's regrettable that this issue is even before the court today. Notwithstanding the obstructive approach of the claimant, Jones Day gave them multiple opportunities to engage in a timely fashion. So on a principled basis, and in line with the overriding objective, the court should not issue the claimants further indulgence at this point. Moreover, as indicated by Jones Day in correspondence, and this is set out at paragraph 62 to 64 of our skeleton, the impact of the claimant's delay is going to cause serious difficulties for the defendants. They will have to reopen their one-level review process. They may have to redo the CAL algorithm. This may flag additional documents which have already been subject to 1LR review and subsequent expansion of the overall document population, and is going to cost a significant sum of money. If Jones Day are to do that task, it's going to be in excess of $100,000. If the defendants have to retrain their third-party review team, that's going to take a period of 2 weeks, and it's going to cost in and around $50,000 before even quality control is done. So we say, on that basis, that should be the end of this matter, and the defendants' keywords, as they proposed on the 14th of March, should be approved. They shouldn't have to open the first level review, retrain the review team, or incur the additional costs, because the claimants didn't deign to respond at the relevant time or within a reasonable period. And my Lord, we say if the court is to consider the claimant's proposals, there would need to be an exceptional reason to impose that burden on the defendants at this stage, and very good reasons to include the words proposed. And we say that's just not the case with the claimant's proposals. One, we say the keywords proposed for all 3 repositories and the justifications provided are not sufficiently exceptional, nor are they pertinent to the issues with regard to the repositories in issue. They are unlikely to produce relevant documents. And 2, the cost and time it's going to take to do these searches is disproportionate to the utility of the exercise. If these words were truly so important, they would have been proposed by the claimants a long time ago. So, my Lord, turning to the specific Hypersuite repository, my Lord, if it might be helpful to turn up the claimant's draft order, because the court can see where the additions come in the context of all of the keywords proposed. And that's at 5159.
Where am I going to find 5159?
I was hoping it was in your bundle, but my lord, it may be an additional or supplementary bundle.
Yeah, let's just have a look. It was sent to me, I think, separately. That doesn't make sense. The additional material I've got starts at 5176, whereas the previous material stopped at many pages before that, but I'm missing 5159.
My lord, it should be on page 24 of the PDF. I'm instructed that there are 29 pages in the additional PDF, and it should be on page 24. If that makes any sense.
No, just tell me what you want to say, and I'll manage somehow.
My lord, I might have a workaround for this, which is that we can look at the claimant's original proposed draft order, because these particular points haven't changed, which is at page 4562 of the main bundle. And the relevant page of the appendix is 4565.
That doesn't help me either, because my bundle stops at 4471.
Okay, my lord, I'll make my submissions and try to do it without referring to the document, albeit it would be useful for you to see it.
But I've got a handle, I think, on what's required, but so you just addressed me without reference to the document.
Okay, thank you, my lord. So my learned friends have given their justifications for the inclusion of the additional terms for this repository at paragraph 18 of their skeleton argument. And they are, in summary, they are meant to capture documents relating to the breakdown of the joint venture between D4 and Alpen Capital. 1, the allegation that the first claimant's clients were told that the company would be merged with D5. 2, and to capture documents referring to the incorporation of D5. 3. So we say, we endorse the description of the Hypersuite database given by Mr. Shivji in his earlier submissions. It's a formal banking database. The documents are formal in nature, KYC, contracts. It's not a database that includes client communications or emails. And we say those are the repositories where discussions such as the divorce of the JV parties or the incorporation of D5 would be discussed, not in client contracts or KYC information. And we say we are already applying these keywords in hundreds, if not thousands, of searches across those databases and the custodial documents, where we say the potentially relevant material will be. Now, the claimants suggest that the defendants agree that the crude numbers arising from the Hypersuite searches would not be disproportionate. And we say that's an inaccurate reading of the defendant's position. Whilst we say 498, 823 or 161, whatever the number is, in and of itself may not be offensive. What we do say is requiring the defendants to embark upon a process to do that review properly is disproportionate because of all of the reasons I previously mentioned, my lord, rehiring 1LR reviewers, so on and so forth. And we say it's not proportionate given the unlikely relevance of these documents and given how late in the day this is being proposed. We just don't see how the hypersuite is going to produce anything of relevance in relation to these search terms when we're already doing searches elsewhere, and we just don't think it's proportionate. So, my lord, those are my submissions on hypersuite and the claimant's keywords.
Right. Do you want to deal with the D5's W drive?
My lord, on those I haven't yet addressed you. So
I know, but
I think I'm in your hands. So I'm so sorry. I apologise for interrupting. I'm sorry.
Not at all. The most economic way, I think, would be for Miss Bell to deal with everything that she wants to deal with, and then you can have the opportunity to respond.
Thank you, my lord. I'll move on then to the D5's W drive.
Yeah.
These again were initially proposed by the claimants on the 14th of March. First proposals from the claimants came on the 4th of July, and they proposed, we say, significant additional keywords. And when we ran the additional keywords, the hits were well over 7,000 additional documents.
Yeah.
Then on the 15th of July, a further iteration of these keywords were provided by the claimants, which effectively the further iteration was a refinement in two regards. The date range for the Singapore or BOS material be limited to March 2014 to December 2014, and the searches for AK to be limited to exact matches, which would exclude references to a Turkish bank, which also responds to the term AK bank. Again, my lord, the first time we saw any justification for the inclusion of these terms was in the claimant's skeleton argument. And we say there are similar reasons why these requests should be rejected. The keywords and proposed justifications do not really make much sense with regards to the repository. They're unlikely to produce relevant documents, and the cost and time to produce them would be disproportionate. My lord, turning to the justifications, the W drive is the fifth defendant's equivalent of hypersuite. So again, it contains very formal documents, KYC, client contracts, and so on and so forth. Keywords such as Karafi, AK, and Walia are said to capture documents relating to the JV between D4 and Alpen Capital and the Al Karafi proceedings. We say those justifications are quite vague in and of themselves. They're not necessarily relevant to these proceedings. It's unclear why the fifth defendant's repository should be being searched for such vague justifications. We say the refinement of AK Bank to AK is not going to assist because AK Bank is usually two words anyway, so we're going to get the same terms flashing up. It said that the Singapore keywords are intended to capture documents regarding the fifth defendant's hiring of the private banking team from Bank of Singapore. We say a database holding client documents and other shared saved documents is not going to contain any information that is relevant on that issue. Custodial documents, yes, they are being searched, again, with hundreds and thousands of searches using the claimant's proposed keywords across custodial databases. They have also already received the employment contracts of the Bank of Singapore team, which were hired. Astruc, Carton, and Sassoon are being proposed because they're intended to capture documents relating to Ds 1 to 3 and the potential involvement in the decision that led the majority of the first claimant's client base and RMs moving to the fifth defendant. And they say any documents referring to D1 and D3 by name are likely to be relevant on this issue. My lord, we disagree. First, the date ranges for these three individuals are completely unjustified and too broad. The point alleged against the defendants by the claimants relates to a time of between May and December 2014 on the pleaded case. BSA had no clients after September 2014, and it's unclear why the date range needs to be expanded beyond that. Again, any mentions of these three individuals involved in a conspiracy or fraudulent conduct would be in custodial email documents, not in D5's repository containing client documents. Moreover, the individuals named, Mr. Astruc, is a general counsel of J. Safra Sarasin. He may be mentioned in documents for wholly unrelated reasons in this repository. Mr. Sassoon, again, his name will appear in documents for wholly unrelated reasons. So we don't think that these keywords are fit for purpose in relation to this repository. We're not saying they're not relevant. We're conducting searches over the relevant repositories, but we just don't think the disruption, cost, time and energy that this is going to take to review is worth it, especially in the context of the defendant's keenness to get this resolved at an early stage. And even on the...
What date range have you used in relation to the other custodians file for Astruc, Carton and Sassoon?
My lord, I'll need to take instructions on that point, but I propose if you can give me a minute, I'll just take instructions if that's acceptable.
You carry on and someone can feed you the information.
Thank you, my lord. Thank you, my lord. The final point is the fifth defendant's hard copy documents. Now, the keywords proposed by the claimants only came on the 15th of July, so even later than the other two repositories. And our submissions are the same. They should be rejected for similar reasons. Looking at the draft order of the claimants, the keywords that defendants have proposed in relation to this repository are going to catch all of the issues that might be of concern to the claimant. So to use an example, my lord, one of the defendant's proposed keywords for this repository is call report. So all call reports that have taken place between clients and D5 or their RMs will be caught by the defendant's keyword searches. So the additions to catch Karafi, BSA and AK, we say in this repository, which again is going to be composed of almost entirely client documents and formal forms and things like that, they're not going to add anything, but they are going to add a substantial burden to the defendant's task. So on that basis, and in view of my earlier submissions, we say that they just aren't justified. They came on the 15th of July, and we say our search terms are fit for purpose. They are going to catch the relevant material across both custodial and non-custodial repositories. So in my lord, those are my submissions on the final repository. I'm going to take further instructions on your questions so that I can come back to you with a clear answer.
All right, thank you very much, Ms. Bell. Yes, Mr. Shivji.
So, my lord, just to point out that on these three repositories, the court has not previously made an order in relation to them, and both parties seek an order from the court on the keywords. So this argument about the keywords really turns on the additional keywords that we've added, and that's for hypersuite. There's 4 keywords. There's about 10 terms in respect of the W drive, and there are 3 terms in relation to the hard copy documents. So this is an issue that both parties say you've got to address. You've got to identify what the right keywords are for this repository, and they want you to make a ruling either to have the defendant's words or to have the slightly expanded words with the claimant's words. So that's the first point. The second point is that we say that for each of these categories, the keywords are likely to reveal illuminating documents that are not captured by other searches. And I'll come back to that by having a look at those specific categories. Also, just putting this dispute in context, on the defendant's own analysis, they have manually reviewed over 240,000 documents in their exercise so far. That's at page 4449. You don't need to turn that up, but that's the reference. On their security for cost schedule, they have, as at the 4th of July of this year, already spent a total of $2.8 million on disclosure. And they also explain in that schedule that they've had 43 different fee earners internal fee earners working on this case. And of those 43 fee earners, 23 of them are under 2 years PQE. So that is excluding this reviewer team that they had set up, and they say they've now disbanded the first level review team. That's just the core legal team. It's 43 fee earners, of whom 23 are under 2 years core. And it's worth just having those numbers and the scale of their disclosure exercise in mind when one looks at the amount of time and effort that has been devoted to arguing over whether they would actually carry out these additional searches. Now, just dealing first of all with Hypersuite, my learned friend seemed to suggest to you that it would cost $50,000 simply to scale up the team to do the Hypersuite review. And that just doesn't make any sense. It's 500 documents. They don't have to put the first level review team back together in order to review those documents. It could just be sent off to one of the fee earners who's under 2 years qualification, who's already worked on this matter and so is already read in, and it's a day's worth of work. And it's difficult to see why, even at Magic Circle firm rates, why that would cost more than $5,000. And so that's why I say to you the cost that's been devoted to arguing over this is going to dwarf the cost of doing the exercise. And my learned friend didn't actually tackle the point that it would take that one person 1 day to do it. So we just think the Hypersuite point really doesn't go anywhere. My learned friend's sort of principal point is that we're too late. We missed the window for asking, and we should be punished accordingly. And I'm sorry that we didn't make these requests earlier. I do recognise that one must be as efficient as one can in giving suggestions for searches. The reality is we didn't. And we are now where we are, which is we're 2 months away from disclosure. We're talking about a 1-day exercise. And it's a 1-day exercise in relation to documents which are responsive to terms which are interesting to this case. We say those terms are illuminating. It's striking that there are documents that are not captured by any other searches that are responsive to this criteria, and they ought to search because ultimately your lordship needs to have the relevant documents to decide this case fairly. And sorry, my learned friend also suggested that they might have to reopen their CAL process for these documents, but that just doesn't make any sense. They should just manually review them. So that's the Hypersuite. Moving on to the W drive. So this is the fifth defendant's shared drive to store client-related documents, and that was in 1705 of Miss Martingale Howard's third statement of Paris 79. So that's what this repository contains. Now, it is striking that that repository is responsive to the terms that we say are interesting. Carafi. Why is it that the fifth defendant has documents on that drive referring to Carafi? They don't suggest that the Carafis were a client of theirs. They don't suggest any of this is client-related document for another client. For some reason, sitting on that server are documents referring to the Carafis. And we say the obvious inference is that that is all related to how the fifth defendant was born, which was, as we say on our case, a conspiracy to defraud the first claimant's creditors, including the Carafis, and to avoid the judgment being paid. And so the Carafi keyword and the AK keywords we say are very relevant. My learned friend has raised this point about AK Bank. AK Bank is a Turkish bank, and it will remain to be seen whether actually there are material numbers of documents relevant to a Turkish bank that are sitting on the fifth defendant's servers, or whether they're actually references to the Karafis. But that can be excluded. I mean, we'd suggested AK as an exact match. If my learned friends want to propose an exclusion to exclude AK space bank, that's fine too. We're not asking for documents about the Turkish bank. And that actually seems to be, aside from the Singapore documents, the single, aside of the Singapore documents, the single largest repository. So actually that may be a way of cutting down that repository. And then in relation to the searches involving Singapore, they are all in the context of the new team, which had just been hired, and the terminologies are very specific. So we say, again, if that's responsive, it's because it relates to the hiring of the new team, and we say that that forms part of the chronology, which relates to these the conspiracy that we allege. And just by way of reminder, the time period of May 14 to December 14 is exactly the same time period that has been applied to Mr. Bukshi's documents, and he was the CEO of the fifth defendant, who himself was hired from Bank Singapore. So that deals with the Bank Singapore words. Then moving on to Mr. Astrup, Carton and Sassoon, it is so Mr. Sassoon was never a director of Mr. Astrup was never a director of the fifth defendant. So insofar as there is documents referring to him, that is striking. And in relation to Mr. Carton and Mr. Sassoon, what we're trying to do is cover the period before, essentially when they were in their role for the first claimant, rather than when they moved on to a new role solely in relation to the fifth defendant. So we've chosen the time periods very carefully. Documents relating to them, again, are likely to be very illuminating in terms of whether they were actually acting in breach of their fiduciary duty to the first claimant. And then similarly, in relation to Mr. Walia, why would there be documents sitting on their server in relation to Mr. Walia if it doesn't relate to the same thing, which is the divestment of the business? So we say that we've chosen our words very carefully. It is striking that there are a material number of responsive documents to those categories. We have proposed a way of cutting down the responsive documents. I mean, they say that on the W drive, there are a total of 7,505 documents that are not already within their review population. They haven't calculated the impact of our proposed exclusionary search, which would further reduce that population. But even taken at 7,505, that is one person taking 15 days. So it is just not an enormous exercise in circumstances where they've reviewed 230,000 documents. And then that brings me finally to the D5 hard copy documents. That's an even smaller pool of documents. So the total number of documents, the total number of hard copy documents is only 4,549. The defendant's existing keywords capture nearly 2,000 of those documents. So at most would only be 2,500 documents up for grabs, i.e. 5 days of review, one person's review time. And the keywords in dispute are only Karafi, AK, and BSA, the name of my client. And we say again, why does the fifth defendant have hard copy documents referring to Karafi, AK, and my client, unless it's relevant to this case? So we think they're actually likely to be the most illuminating category of documents. My lord, that's what I had to say on our request of their disclosure. Moving separately to the claimant's disclosure, I'm grateful for what my learned friend had to say. It sounds like in principle we're agreed on that. They've got some questions and they want to be satisfied that we have that what we've said is based on a proper inquiry. My proposal would be we will deal with that in correspondence. You have that from me. My solicitors hear that. I will tell them that's what we have to do because I've said it. So we will engage with them on those points in correspondence. I would ask you to make the order that we seek. And of course, if in due course my learned friend is unhappy with what we say in correspondence, then woe betide us. We'll be back before you on the 3rd of September. But my proposal is that across those remaining claimant issues and the remaining defendant issues, that sweeps up all of the keyword searches and allows everyone to get on over the next 6 weeks with what we need to do. Now, if I may, my lord, can I just pause for a moment and check with my learned friend, Mr. Sharafi, if there's anything else? I'm grateful to my learned friend, Mr. Sharafi. On Avaloq, that isn't an issue for you today. The defendant seeks an order for approval on their Avaloq terms, which we're content with. We've made some very modest proposals for some additions. They want to investigate those issues. I'm happy for them to investigate them. Obviously, I reserve my right for them to be added later, but let them have their chance to investigate. So I would say on that, we're agreed. Order what they've asked for, whilst noting that I'm reserving my right to come back if absolutely necessary.
Right.
That's everything, my lord.
Thank you, my lord. May I make a few points in reply, very briefly?
On what?
On Mr. Shivji's submissions on the defendant's repositories where keywords are sought.
Yes, if you want to.
Thank you, my lord. 5 very brief points that I want to make. The first point is in relation to the submissions as to the size of the disclosure exercise that's already been undertaken by the defendants, which is 240,000 documents, a very large team and a significant sum of money. In our submission, that's an aggravating factor to adding even more documents to their search. They've already done an extensive and very expensive exercise, and adding several thousand documents at this stage, we say is not a mitigating factor at all. It's an aggravating factor. Second, the reference to the CAL algorithm and the destabilization that might occur, the claimant's response to us is, well, you can just do it without CAL or just create a new one. Well, we say, well, that's not a good solution. One, we want to use CAL. Why shouldn't we be entitled to use it? We've already trained it. Two, with the small repositories that are being sought by the defendants, and a document field number of, say, 8,000 is not really going to work with the CAL algorithm. It needs a larger number of documents to be stable. So we're going to end up having to review them all by hand anyway. So that's not a workaround. And we say that without CAL, it's going to be more expensive. Three, my learned friend made submissions to the effect that, well, it's interesting that terms such as Karafi, etc., are flagging up on the repositories. Our response to that is, well, we haven't actually broken it down to the number of hits per search term. And actually, Jones Day did look at some of the documents that were being flagged up, particularly in relation to the W drive, where those documents on the claimant's additional keywords go into the thousands. And at page 4461, they address this in correspondence with the claimants and say, we've looked at some of the documents that are coming up and we haven't found any relevant documents. They all relate to banking product information from the Bank of Singapore or AK Bank. So we say it's not clear at all that any of these documents are going to be pertinent. 4, my learned friend made submissions on the impact that this is going to have in terms of time and cost. If all of the defendants or the claimant's requests are granted, we've done the math and it comes down to, on our first level review, it takes 26 documents per hour at being reviewed. So we say that 7,500 documents would take 288 hours, and for a Jones Day associate or junior associate to do that, that would be $450,000 per hour. That's almost $130,000 without training quality control or supervision. So whoever does it, even if it's one person for 15 days on my learner friend submission, that's a significant sum of money, and it's a significant amount of time given we're at the 17th of July and the disclosure deadline is the 22nd of September. So it's not an easy ask at this point in time. My lord, I said I had 5 points, but I think I'll leave it there, and those are my points. And sorry, my lord, I'm just getting instructions. You could bear with me. Yeah, my lord, the final point I want to make is in relation to being on an equal playing field, and I don't like to go back to previous conversations between the court and parties, but in November 2024, the defendants were heavily criticised because they hadn't responded to the claimant's proposed keywords for a period of 22 days, and the court went on to make orders for the claimant's keywords on their proposals, and the junior counsel for the claimant said they've had plenty of time and the parties should be able to get on with their exercise, and the court agreed. And all we're asking the court is to hold the claimants to the same standard and not to put the defendants in this position or to this expense in the circumstances. So, my lord, thank you for the court's indulgence. Those are my submissions. I should just say on Avalok and the audio recordings, we're in agreement with the claimants. We'll engage in correspondence, and if we can't come to a sensible landing position that's agreed, we'll come back before you on the 3rd of September, but I hope we don't have to.
Very good. Thank you. Thank you very much. I have to deal with questions arising from the use of keywords in relation to 3 particular depositories. The first point to note is that there has been no prior order of this court in relation to the keywords, and the court has to determine whether or not simply to approve the keywords already used by the defendants, or to require the defendants to use additional keywords as recently put forward by the claimants. So far as the 4th defendant's hypersuite drive is concerned, the additional words which the claimants wish to be employed relate to the possibility, relates to the formation of the 5th defendant as a new company and concepts of merger or divorce. So far as the 5th defendant's W drive is concerned, the additional words relate to the Karafis in one form or another, Mr. Walia and the Bank of Singapore, as well as the additional words to which I've already referred. In relation to the hard copy documents, there are again words that relate to the Karafis and BSA. The defendants essentially say this is all much too late. The claimants failed, so the defendants say, to respond to their own keywords, which were put forward originally in the letter of the 14th of March until the 4th of July, some 16 weeks later. This is partially explained by the without prejudice negotiations and funding issues, which have been the subject matter of activity by the claimants during that period. It is also said by the defendants, however, that the claimants were able to engage with other elements of disclosure, and particularly their own disclosure during that period, so that this is not much of an excuse. The defendants say that the ILR process has been completed with existing keywords, and that there would be a need to retrain the ILR reviewers and rerun the CAL process if these additional words were now to be utilized. This would result in substantial time and cost, with a potential domino effect upon existing disclosure. Moreover, the defendants say that this prejudice was forewarned in Jones Day's letters of the 14th of April 2025 and the 7th of May 2025, the latter of which included a threat to go to court to order the keywords which had already been utilized. It is now said that something of the order of $50,000 to $130,000 may be involved in expense should the defendants be ordered to do what the claimants suggest. It was suggested in letters that pursuing this course would threaten the ability of the defendants to meet the 22nd of September disclosure deadline, which is some 9 weeks away. It was not said that this was not possible, but that there was a threat in that respect. To my mind, the real question is whether these additional keywords may result in significant material disclosure. If so, given all that has passed between the parties, to my mind, the burden involved in effecting the work at this stage would not be such as to justify refusal of the searches. The irritation that the defendants express at holding the claimants to different standards from those to which they themselves were held in relation to the keywords put forward by the claimants back in November last year is understandable. But the failure to respond to the proposals on the part of the claimants is largely a consequence of the agreed adjournment of the CMC, fixed originally for April, and attempts at settlement which have not borne fruit. Of course, the claimants could have continued with such work and come back on these points during that period, as they did in relation to one or two elements of their own disclosure, as has been pointed out by the defendants. But turning to the substance of the issues between the parties, I deal first with the issues relating to the fourth defendant's hypersuite file. Applying these new additional keywords, only 498 documents have been hit, of which I understand only 161 to be new documents. That is such a small number that review is obviously straightforward. I accept that because this is a client business file, the defendants may be right in their submission that it is unlikely that much would be found, as the file consists largely of contractual documents. Nonetheless, the new keywords are keywords which have been previously agreed for searches of other custodians, and these keywords are intended to capture documents relating to the allegation that the first claimant's customers were told that the claimant would merge with the fifth defendant and details of the incorporation of that company. I consider that the additional work required here is not such as to call into question the need for the use of these terms, which may reveal something significant, as the claimants suggest. So far as concerns the fifth defendant's W drive and the addition of AK, Karafi, BSA, and AK, and other keywords to which I've already referred, The defendants say a sample of 7,505 documents hit by these additional searches reveal nothing. But again, in my judgment, this is an important area because the question arises as to why any of these additional keywords would give rise to any hits at all. There may be significance in that. The creation of the fifth defendants as a means of defrauding the first claimant's creditors is the basis of the conspiracy which is alleged. There is objection because of the use of AK, which can cover a Turkish bank, and there may well be room for refinement of the AK search term in order to exclude documents which concern that bank. But I regard the questions relating both to the Karafis and the Bank of Singapore as critical in the context of the basic allegations about poaching the first claimant's business. Even if one takes the quantity of 7,505 documents, which falls to be reduced by reason of the refinements to the searches that have recently been suggested, the numbers are not huge. There is now a reduced date range. A new CL model could, in theory, be set up, but in practice, this is likely to be simply another question of manual review, all of which is perfectly capable of being done by the deadline of the 22nd of September. So far as concerns the use of the names of Astric, Carton and Sassoon, the end dates now provided are those when they began to work for the fifth defendants. The documents sought are intended to capture involvement of these individuals in decisions leading to the movement of the first claimants, the relationship managers and customers to the fifth defendants. I regard these matters once again as being of significance. Of course, at the end of the day, nothing much may be revealed, but in the overall context of this dispute, the additional work to be done appears to me to be a drop in the ocean. That leads me to the last question, which is the hard copy documents, where there are 1,938 documents which are captured, and a review of these would be required. Once again, the question as to why the Karafis names and BSA name should appear at all in such documents. Again, I cannot see that the numbers involved here are such as to render this exercise unnecessary or disproportionate. So for these reasons, I accept the claimant's contentions, subject only to any question of refinement of the term relating to the Turkish bank, with a view to excluding all such documents by use of some appropriate wording or initials. I'm not required at this stage to deal with anything further regarding the claimant's documents. Questions have been asked, which Mr. Shivji says he will ensure are dealt with, and if they are not, and there remain issues to be determined, I will have to deal with those at the 3rd of September CMC. Right, now is there anything else?
Not from me, my lord.
Ms. Bell?
The only other matter was a point raised by you, my lord, which is in relation to the settlement discussions that the parties had previously been involved in, and you mentioned that you did want an update, or insofar as an update could be provided.
Did you hear what Mr. Shivji had to say about that?
Apologies, my lord. I'm just taking some instructions.
Basically, what he said was that I couldn't be told anything more, but there might be some way of providing for the court to be given an update as and when, and that he would liaise he and the claimants would liaise with you and the defendants to work out what could properly be said to the court and what couldn't, bearing in mind the commitment that the court has in relation to a significant period of time for the trial. Unless there's anything further that you can add to that, that's probably as much as can be done.
My lord, all we wanted to add to that was to refer to footnote 1 of the claimant's skeleton, which just indicates that there is obviously a dispute between the parties as to what can and cannot be said to the court, and that is going to be the subject of a separate application, and that's all the defendants would like to add at this stage.
Yes, well, I was aware of that because I was told not to read certain documents on the court file until that matter had been resolved. So, as I say, it just helps the court to have some idea where this case is going because of its other commitments and the impact on other court users. All right, that's very helpful. Thank you very much. Anything else at this point? I was thinking simply that costs would be reserved.
I think on cost, my lord, I think we've both suggested costs in the case in our draft orders, so we'd be content with that. I mean, these are usual CMC matters. We're content with that.
Yeah, costs in the case. That's fine. Now, are you going to be able to agree a form of order in the light of what I've said? What I don't seem to have been able to find, Mr. Shivji, is your draft order. I've got a copy of the defendant's one, but as long as you are confident that you'll be able to agree the terms of the order, then I don't need to trouble myself further.
Well, I know there's some past history on this front, which we will look at ourselves with regret over. You do have the court does have a copy of the draft order. It may not have made its way to your lordship, but I would suggest, I'm very grateful to my learned friends, in particular, that we've had engagement between the council teams. They've been extremely helpful in terms of trying to use the time wisely today. So we will make every effort just to agree that offline in the usual way. And I know that, as I said, the past history has not been happy on that front, but we also understand that the court has no patience for squabbles about the terms of orders. So it's a professional obligation on all of us to get it down. And your lordship has been very clear about the order. And we are also back before your lordship in September. So with all that in mind, we will get on with it. I also know that sometimes it's taken a long time for us collectively to send something to your lordship. And I also recognise that that is unhelpful because it's fresh in your lordship's mind now, but it won't be in due course. So I think we will take that as encouragement to get this done swiftly.
That would be very wise. The longer it is delayed, the less I shall remember, and the more impatient I'm likely to become.
Well, that's with good justification, my lord. So we will take that, and I mean it isn't actually a very long order, but we will crack on with it.
No, all right. And when we meet again in September, I can't quite remember what other CMCs we have planned, but we may need just to review the position to see if we need to fit in some others simply as a matter of routine, so to speak, to ensure that as this case goes forward, it still does go forward at the pace that's required. I'm particularly thinking about that in the context of any letters rogatory or anything of that kind, because as Mr. Shivji has mentioned, and I think the defendants are very well aware, any process of that kind is enormously time consuming, and indeed out of the control very largely of those who instigate it. That's just how life is, I'm afraid, in other jurisdictions. All right, well, let's leave it there then, and thank you all very much for your assistance this afternoon, and apologies to the court staff for keeping them late. And if anybody is thinking of a holiday, I hope you have a good one.
Thank you, my lord.
Thank you.
All right, if you'd all like to sign out, I'll just have a quick word with the assistant, the associate.